Good morning. It's Wednesday. Yeah, February the 25th. Mercy. 3 more days in this month and it's over with, and I swear it feels like it just started. Mm. Well, I know yesterday I started the stream and everything was going fine. And I got a phone call and I was on the phone, which is not attached to my computer at all. And all of a sudden, the stream was gone. There was a blue screen, the trial. So I was like, well, tried to restart it. I couldn't find the right place. So I was like, screw this. I just restarted it all. I went in and deleted the original one and then just restarted it. So, but yesterday morning I was talking, and Mike and I had decided that the office, because we have our offices set up here in the house, we each have, a desk in the office. Well, I was like, okay, this thing needs to be cleaned. Because, let's be honest, we don't turn our furniture over every day and clean underneath it. So things get kind of, you know. Anyway, we started doing that on Monday. Yeah, Monday. And I kind of got, because the office is right off of the family room. And I got the office and the family room, because what we did was we moved everything from the office into the family room so I could clean the carpets and move the rugs and all that, all that good job. So I like the office in the way that we have it now. It seems to flow a little better. Um, I like how I haven't finished the family room. I still got to finish the family room, but it's not as bad because it's full of stuff. So it's easier for me to keep the family room clean. Easier, rather, for me to clean behind stuff and under stuff than it is in the office. So, but we got that done. And man, I tell you, there ain't no better feeling than to have a clean house. It doesn't feel too good when you're in the process, because I'm gonna tell you something. By the end, let's see, I think it was like 4 o'clock. I sat down and took a break about 4 o'clock. Well, that's the first time I looked at the clock. And I was like, Jesus, it's almost 4 o'clock. And I had started that morning about 8 o'clock. But I really do like how it's set up. So, but what we're doing today is we're gonna stream. And yes, I'm starting a little earlier. Excuse me. I haven't been up long. But I figured I'd go ahead and get started so that I could come on early before hubby wakes up and come in here and have a little chat and talk about some things before we get it going. Because when he gets up, I want to spend time with him because, I mean, he's got to work tonight. So one thing I noticed this morning, I don't know how many of y'all know who or follow this channel called Cluminati. Oh, my glasses. I was scrolling, through YouTube this morning, like I do every morning. And I heard somebody say something about that's live right now. Something about Cluminati's channel was gone. And I'm like, huh? So I went and looked, and sure enough, her channel is completely gone. I mean, I heard them say that she said she was going to appeal, but that she probably wouldn't win it. So, I don't know. But while I do follow Cluminati's channel, I did watch her. I did enjoy her channel. I got a whole ton of laughs. But me as an individual, I could not do what she does. I could not do that kind of content. Because I feel like, and this is just my personal feelings. This isn't saying that that's what she's doing or anything of the like. I mean, to her, she's probably just having some fun. But I've also watched the channel that she um reviews, for lack of a better word. Um and while I'm not a big fan of that channel, I really don't, I couldn't do the things that Clue does, or say the things that Clue says, rather. Because Clue doesn't do anything. She's only on a computer talking. And that's my biggest thing with these lawsuits. I mean, okay, someone's on YouTube and they're talking about a public video you put up. Okay. They got every right to. But here's how I look at it. And this is, I don't think there's any simpler terms to put this in. Everybody's hollering, oh, I got First Amendment rights. I've got these rights. I've got these rights. I want to inform you of something that the majority of us probably never sat and thought about. But our rights as an individual, they end the minute our rights start stepping on the rights of someone else. Simple. You've got every right to say what you want to say. Sure do. The other person also has rights to retaliate And because you decided to do what you did or say the things you say, there's consequences. And I don't care who you are, you will suffer the consequences. Clue had a good run. She can't complain. I mean, she had thousands of followers. She was making all kinds of money. Snapchat, super chats, memberships, all of it. So, but where I draw the line is talking about someone else's family. Whether it be their children, their grown children, their young children, their mamas, their daddies, their grandparents, I don't care. You don't know the first thing about any of these people. I don't care what you look up on Google. And I don't care what you think you heard them say. You don't know them. You got no right talking about it. And the one thing that really upsets me and pisses me off is when creators want to talk about another creator's children that are minors. See, the difference with me and these other creators, which I'm not a creator, I'm just a business owner, talking about my children, especially my minor children, would plant my feet on your front doorsteps with a knock on your door. I don't need no police. I don't need no court. You mess with my children, and I'm coming. That's just me. You don't mess with someone's kids. Your asses are on YouTube. It's social media. Keep it to social media. You don't bring a lawsuit unless there's something really bad going on. And oh, because somebody talked about you is not reason enough to bring a lawsuit. Anybody that brings a lawsuit against another creator on YouTube for just talking about them needs to be charged with the crime. That right there is just absolute disrespect of the courts and our court system. You're tying the courts up for some bullshit. But I mean, there's always been mean people, and with the way society is going, they're breeding a lot more mean people. But I don't think someone should lose their channel simply for having an opinion on someone else's content. Do I feel like that falls underneath fair use? Not really. I mean, you can review and you can, stuff like that, but they some of these creators have just went way too far. When you start looking up a creator's family and their kids and their parents. It's a little obsessive, don't you think? And when it comes to obsession and you're just focusing on one person, in my opinion, that constitutes stalking. I mean, hell, to me, sending a damn card to someone that doesn't want any contact with you, that's stalking too. But you know, any unwanted contact is stalking, period. I'm not sure why there's so many adults that their brain can't process what stalking is and the many different forms of stalking. But either way, that's them. It's not me. I can't I can't sit and talk ugly about someone that I've never met face to face, never had a conversation with face to face for hours and hours and hours every single day, going online and talking about them 3, 4, 5 hour long lives. And that's all you talk about, pretty much, is this one creator. Don't be surprised when your channel gets gone. It is what it is. Like I said, I do like Clue's channel. I have gotten a lot of laughs over there. Don't necessarily agree with the way she does her content or the things that she, or everything that she says. But I do get a few chuckles. And hey, with the way that I work, laughs are always good. So there's that. But today we're going to stream day 9 of the Murdaugh trial. As we were ending yesterday, we heard Judge Newman say Monday, I think he said 11 o'clock, if I remember correctly. It's what time he wants the jurors there. So this one will be on, I think this will be starting the second week of his trial. So, and I started his trial from on day 1 of the actual trial. I didn't do the picking of the jury or nothing like that. I just started with the opening statements. So, but this is day 9, and we'll see what comes about on today. But I do want to thank you for joining me. Thank you for listening to my 21-minute spiel. And do me a solid and hit that subscribe button. It's totally free. And if you like this video, give it a thumbs up. Thanks, guys. Let's get into it now.
Please be seated. Good morning. You ready to proceed? All right, may proceed.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to record in this trial shall be the truth? So help you God.
I do.
Take a seat in the witness stand. State your name again for the records. Spell your last name.
Morning, Your Honor. My name is Mark Tinsley.
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would were you testifying before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And how long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
Do you have a statewide practice, or is it primarily?
To the extent I want it statewide, I mean, I handle cases statewide if I'm inclined to handle those.
Okay. Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
Yeah, the first. Okay. Do you know the defendant, Alex Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alex Murdaugh. Is that correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, when this case started.
Mr. Waters, my recollection is that I sued Alex Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believed that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdaugh, which is Alex's son. But I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Okay. Now, can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday, so the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about
I'd have been mad about that too. I'd have showed my real loving ass.
proceeding forward in this particular case? Is pardon based on that experience?
No. Nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
Sure. My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alex's personal lawyer, brought me all of Alex's insurance policies, and so I reviewed them at that time, before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
You know, in a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes, when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right. And what did you determine as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was a Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy. And so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusions. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge, is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage, had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing what insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was. No, 20. September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
Yeah. COVID. The court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's if it's May or April, then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. Hold on. We'll show you what's been marked as Exhibit 401, State's Exhibit 401, and see if you recognize that document.
I did. I do.
All right, and what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right, could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alex said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel, and about a week after I'd filed that motion to compel, Danny Henderson, who again was Alex's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right, and why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever, and so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alex thought there was a fix on, that he was just a placeholder, a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alex, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take, the analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just wasn't, there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alex was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see.
So when you say, okay, you say he's broke, I don't believe that, show me the books to prove that, what was your response from Alex's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. I'll show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alex's responses to the interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right. All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can
right.
you read that?
List all checking and/or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and/or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
All right. And ultimately, what was the Alex defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
Okay. And so ultimately, you filed a motion to compel, is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others, is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alex attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon ultimately. I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case, is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, you know, the way to, again, like I in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, you know, that's what I'm trying to do, is put pressure on him to force him into a settlement. You don't want it disclosed? Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alex's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up. Lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right, let me put this up on the screen. All right, if you would, got this up on the screen, so can you tell me what's going on? And again, this is in April of 2021, is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah, so in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I'd just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time I've said that I'm gonna leave the case in Hampton, but if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me, but...
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
I'm going to show you what's been marked as states 404, 405, and 406 to your, for this hearing, and see if you recognize those, please. Generally.
I do.
All right? And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021?
It's either the 10th or my recollection is the 10th. I know the emails say something different, but, and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done, and he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at states 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at states 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right. Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as states 407 and states 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right, so the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec, all identification of all accounts. Is that correct?
It is correct that motion was going to be heard.
And and is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
after the murders happened was, let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I'd known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec, he hasn't done anything, it's Monday morning of the roster, maybe you expect it to be continued, and he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that, show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things, but
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of these and the emotion of the case, which can be so important to recovery?
Yes. It did.
Explain that to the court then.
Well, initially, there was the shock and horror of what had happened, and nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case, so I would have ended the case against Alec.
You would have ended the case against Alec with just...
I probably, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
You had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
At some point, did you receive any call or any communication from the Satterfields about any recovery and the Gloria Satterfield death?
At some point, my recollection is it's early September of 21, Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement, and he came to my office at that time.
All right, and did you send them to someone?
I sent him to Eric Bland.
Hold on, probably one second. Nothing further at this time, Your Honor.
By the defense.
Good morning, Mr. Tinsley.
How are you?
You testified at length to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets, and that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insisting that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from him.
Sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money. No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No.
You believe you were close to taking it to trial?
There was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time
You
frame.
felt like you were only 2 or 3 months away from trial?
Sure.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex, had you?
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard, is that correct?
Correct.
There were many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had one or two motions. Some of the motions got resolved, one of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video for mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter, and it ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
Pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic, do you?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up. I believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental request for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about...
Sir, no one's asked you about that.
Okay.
And we'll get to it, but first let's turn to answers to first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for. Keep Exhibit B. It's the first page of what's Exhibit B in here. It's right there.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts, and then you don't have to highlight or expand the stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property interest of property of every kind whatsoever from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, etc. Profit sharing plans, pension plans, etc. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you?
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
It's the record, October 7th, 2021.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, or answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied, or it's
If it was granted,
premature.
would you say granted?
Well, I think that's what it says. It's a practical matter when parties have discovery motions, oftentimes, like Alec is, in his own statement said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge. So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
This is visible. I just want to get the date that this order is, which is October 6, 2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before let me finish my...
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit, I believe.
And this was like a dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action,
Okay.
yes.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge what I've handed you, but...
Sir, I asked you what the ruling was on the motion
Well,
to compel from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Alec is that Alec had, and his lawyers had, 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight-up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front of the
So you're
judge.
saying the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is, how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alec's lawyers knew what the evidence was, they knew what the amendment was going to be and the allegations, and he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that appears you're suggesting now.
And again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up, and we saw the one that asked for financial information was deemed premature.
Not at all. You know, what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements now. It would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks, there's no way these checks are going to Forge, there's no way that this money should be transferred.
And even if, hypothetically, had this hearing on the 10th, and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him, isn't it true all you would have been all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, that's the measure for punitive damages, net worth. There's no such case, in your opinion, as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right? You just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it.
So,
I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
You wanted pretrial ability to pay discovery to inform whether or not to accept a compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. It would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. But that's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case.
And then I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office, or was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Beg your court's indulgence. If the hearing had gone forward on June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information, but since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he did.
Let me just make it a little bit simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to issue.
Break it down. An order would have issued at some point later, and what, if it were granting your motion, what would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
It's a voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what? Law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alex.
Right. Would you have gotten, what, a financial statement?
No.
The court would have ordered every account detailed listed to you, all those personal accounts? Just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I've told you that a couple
Right,
times.
to subpoena.
Sure.
And,
but that's different
and
than
that would
him
have been
giving me.
resisted, and there would have been further litigation. This process would have taken some time, wouldn't it, if it was resisted, right?
I'm not sure if what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating the same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but, we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
The court's open.
Judge, I've been thinking about you. Thank you.
So just, and maybe we can agree on this. The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying that the fuse was lit when you were going after his assets, and that fuse was going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money. Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right, but it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. No further questions, sir.
Yes, sir.
Very briefly, Your Honor. And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection, Your Honor.
There's only one.
Objection, Your Honor. Leading.
Don't lead the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel Because you had been advised supposedly that Alec was broke and you didn't believe it.
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets.
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec.
from Alec.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol. So only on the documents that were filed.
Sir, were those issues, though, in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed, these are the issues.
I'm going to hand this back to you, but I'll show you what's been marked as States 407 so you can recognize that.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Yes.
Okay. And that's from October of 2021, is that correct?
It is.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Edisto,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Next witness.
Crosby, just to let Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. And thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself, in prep in the evening or whatever, privy to that particular conversation.
Any other comment about the attorney-client privilege issue, Mr. Griffin?
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
And so it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdaugh about, and that's where this is going, or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to Mr. Lee Cope, and is that privilege? I'm at a loss here.
I don't know either, but I say, as far as the law is concerned, that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses and you want to call them as witnesses, if there are necessary witnesses to this hearing, you may proceed.
All right, thank you, Your Honor. We would call Ronnie Crosby to the stand.
Raise your right hand. Raise your right hand. Left hand on the Bible. Do you affirm the testimony about the record in this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Ronnie Crosby, Crosby, C-R-O-S-B-Y.
Mr. Crosby, how are you?
I'm okay.
All right. Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alex Murdaugh?
I am.
You see him in the courtroom here?
I do.
And where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting with in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday, that we gathered at Alex's brother John Marvin's place, which is not very far from Alameda that y'all been talking about. And I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him, and so we gathered there. I was present, Mark Ball was present, Lee Cope was present, John Marvin was present. At some point, I believe, and I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but did the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day, and we were there for support, and he went over the events of that afternoon, or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together, and I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were for me to hear them, I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct, and this was before, I believe, the South Carolina Law Enforcement Division agents arrived at
Activities the night of June.
And obviously, we all were in shock, but also wanted to try to find out what all had went on, because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and it may be pieces and parts, but what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this matter.
Anything further?
Yeah. Please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster could be interviewed by SLED, is that correct?
That's correct. The purpose was to, that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that, that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin, over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed. And Jim, now that you speak of it, I do think that while Mr. Randolph did not come into the meeting, he and whoever brought him over did come by. Those are two that I'd forgotten.
Yeah, and
And then went back to Alameda.
where he died within hours of that, right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present.
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not, about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alex some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. Do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him.
Well, did you, or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? Did you give him that warning?
Mr. Griffin, we're all lawyers. Other than John and Buster that were there, I don't think anybody needed to say that, and it never crossed my mind that when we were sitting in a room and all of us were talking, that we were somehow representing Alec.
No, I understand that. And it's, okay.
And nor would I ever do that, because I don't practice in the area that you do.
Right. But it's clear that Danny had an ongoing attorney-client relationship with Alec, is that right?
He did. With regard to the boating accident, he was Alec's personal counsel in that.
And Danny had sat in the initial interview that was conducted by Sledge Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, for support, because.
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the events of the evening of June the 7th. And my question to you is, when when Alex was making these statements, let me make it clear, were they just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and whether John had walked out when I heard any specific thing? I can't tell you that. I couldn't catalog, because I said it's a little bit fluid. People come and go, and law enforcement arriving outside, and people walking out to greet them. I mean, it wasn't like the sled agents just showed up and it was some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please. That's all the questions I have, Your Honor.
Nothing further, Your Honor.
Thank you. This issue.
This particular issue, no, I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we, in discussions with the defense, that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all of this through. And I know that we're butting up with the jury being here shortly, but...
That can be done at a later time.
Yes, sir.
Anything further on this issue regarding evidence of other crimes?
Aside from the side of the road, not at this time, no, Your Honor.
All right. Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but, that would be it. As again, for in-camera proceedings before Your Honor, to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it, unless we did side of the road.
We'll take a break of about 5 minutes, and I will announce my decision regarding this other evidence.
Okay, we will zoom through this little break here that they're having. This was some wild testimony. I don't understand why a lot of this is allowed in, because it's got nothing to do with this particular crime. And it's not even being used as a means for motive. So, I don't know, but we'll zoom.
Please be seated.
This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of res gestae. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing The court has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And before admitting this evidence, the court must first determine if it's relevant. Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence, and the court is to conduct and required to conduct an analysis under Rule 403, which weighs the probative value versus the prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time. The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the state versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife Maggie to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, had been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as a main depository for a substantial, if not most of the misappropriated funds. We heard testimony from attorney Chris Wilson about confronting the defendant about the missing $792 and the personal sum to him owed of $192,000 was later discovered. And that testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother, who was the housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case, and when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from Mr. Carson Burney from the State Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh, because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this case, since the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge. Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but is more probative than prejudicial. As to res gestae, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and the looming exposure of this criminal activity. And the state contends that that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime for which a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred, then that evidence is admissible under the theory of res gestae or res gestae, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res gestae, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged under the theory that the state is seeking to prove, that proof of it is essential to complete the story. And our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. Further, in State v. McGee, the court held that where res gestae, evidence of res gestae or part of res gestae is properly admitted, then no 404B or Lyle analysis is reached. However, as to the finding of admissibility of evidence, which I have done, and the finding of it within the res gestae, I've nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted, I will file a more formal order granting the state's motion later today. Are we ready for the jury?
I believe we are.
Your Honor, one point on Your Honor's ruling. I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence. And so,
Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction.
Schedule will probably be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed limiting instruction?
I'm looking at it right now, Your Honor.
Want me to give this after the testimony or before the testimony?
but before the testimony is offered, Your Honor, from a financial witness.
That's fine, Your Honor. I would just, as to the specific language here, obviously it has, the next to the last sentence has it's being allowed, and it makes a specific representation about the state. It only refers to motive, not identity. It's more of a 404, not a res geste. I don't know that that sentence is necessary. The last sentence, I think, also has a typo in it. But I would, generally, though, I have no problem with this charge, and I have no problem with it being given before such financial evidence is received.
You've indicated those witnesses will testify later today or tomorrow?
Probably not late today, but certainly tomorrow.
All right. Well, you have an opportunity to submit your own proposed limiting instruction or to confer with defense counsel and see if you all agree.
Absolutely. We'll work on that, Your Honor.
Yeah. Of course, you have the other question of res geste and whether or not a limiting instruction is required for res geste testimony.
No, I understand, Your Honor, and I guess I understood the scope of the court's ruling to go beyond res geste or gesti and to include prior events that he wasn't confronted about on June 7th. Now, if the court's ruling is limited to the confrontation on June 7th and about that transaction, then it would be res gesta.
It's not limited to June 7th. June 7th also includes res gestae, but the ruling includes all evidence of financial crimes that may likely have led to a motive, lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record, Your
Yes,
Honor.
sir, I understand.
Showing no disrespect to the court.
No, I understand. Okay, we ready for the jury?
State's ready to proceed, Your Honor.
Bring them on. Thank you. Good morning. It's right at noon. Well, 11:58. It's still morning. We embark on day number 11. Call your next witness.
May it please the court. Yes, sir. From the state of South Carolina, we now call Miss Michelle Smith to the stand.
How you doing? Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Yes. Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Michelle Shelley Smith.
Take a deep breath.
Yes.
What is your first name?
Michelle,
Spell that, please.
Mushell.
Where'd you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
Is it Michelle with a U?
You, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Ms. Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you won't mind just pulling this up a little bit and speaking into it.
Okay, thank you.
Thank you. Go ahead.
I was born in Hampton County. Have 4 grown kids.
Louder, Ms. Smith.
I was born in Hampton County, 4 grown kids, 8 grands, and I worked for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable. Like you said, you had 4 adult kids.
Yes,
And then you said 6 to 8 grands.
it's 8 grands.
8 grands. Okay. And raised where?
Hampton, South
Where-
Carolina.
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Ms. Smith?
Got married, raised my kids, and that's what my profession, that's it. Mhm.
And that is the hardest profession, raising children?
Yes,
You had 4 kids,
4 kids.
and when you were raising them, you were raising them, taking care of the
Yes,
family? And are any of your family here today?
yes, my brother and my daughter,
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up? Is that your brother?
Yes, that's my brother.
And who else is here?
My daughter, Rochelle.
Miss Rochelle, will you stand up? Thank you. They in here supporting you today?
Yes,
Don't take this the wrong way, but other than raising a family, which is the hardest job, were you doing anything else during that time period?
no, till 1995, I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you were raising your family?
Usher, kitchen ministry,
Kitchen ministry?
yes.
And how long did you do that?
All my life, church,
Are you still doing that?
yes.
And you don't have to name your church, but where's your church located?
Fairfax, South Carolina.
So at some point after your children moved up in years or got older, did you start another profession?
Yes,
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
private home care,
I'm sorry?
private home care, caregiver.
How did you get into that?
My aunt,
And was she in that business?
yes, she's an LPN, yes,
An LPN?
Yes.
Licensed practical nurse?
yes.
And when did you get into the home care business?
Probably about 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay, tell them when you started with the school.
It's school in 1995, that's correct, 1995.
And what school did you start with?
At North District Middle School in Warrenville, South Carolina.
North Central Middle, Varnville?
North District Middle School,
North-
yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change
Yes.
locations?
Yes, 6 years later, I went to Wade Hampton High School,
And for those of us that don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School,
So total years in the school system is what?
28 years,
And you're still there?
still there.
So you started home health care while you were still teaching school, or
No,
still going to school?
Going to school, working, food service.
And will you please tell them, you said your aunt got into business. Were you working with one family at a time, or did you have,
Different families at a time, different families.
and how long would you stay with the family once you became their caregiver?
It all depends on how long if they're deceased, I will move on to another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said there's a job, and she let me put me on that job.
So give the jury an idea before we get to this case, your schedule would be what when you were still working at school?
Yes,
and
at the school.
caregiving?
Yes.
Okay, so what was your typical day like?
My typical day was I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
Can you tell this jury, Ms. Smith, how it came about that you started working for the Murdaugh?
It was a job opening. I think one of the caregivers mentioned it to me. And I said, yes, I'd be interested in going. And that's how it started.
And one of the caregivers mentioned your name. Do you know who that was?
Yes, yes, sir.
Okay.
It's Barbara Mixon.
Ms. Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up.
Yes.
And can you tell these folks when that was? When did you start working for the Murdaugh family?
I think it was October of 2019.
And what was your role as a caregiver specifically for the Murdaughs?
Miss Libby, taking care of Miss Libby, Miss Libby.
Was Mr. Randolph, I knew him as solicitor, Randolph Murdaugh, but was Mr. Randolph, was he there living
Yes.
when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeida?
Yes, Almeida's, yes.
What was your primary job as the caregiver? Were you there to take care of the solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby,
Okay. Did you also ever tend to Mr. Randolph's?
every now and then. Mhm.
But your main focus was Miss Libby?
Miss Libby, yes.
From October 19th up to June 21st, Ms. Smith, and I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury today, but did Miss Libby's condition get worse?
Yes,
And she's suffering from something that affects all our families, it's Alzheimer's?
yes,
And that got worse from the time you started until June?
yes. Mhm.
Well, in June of 2021, how would you describe Miss Libby's condition?
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No, no.
All right, specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20, I would leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go back to the school.
So was that the shift you were working for the Murdaughs
Yes,
primarily?
yes,
An 8 p.m. to 8 a.m.
yes.
shift?
Mhm.
When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes,
You would rest?
yeah, that's for a couple of hours. Mhm.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes. Mhm.
Well, ma'am, I'd like to take you to June 7th of 2021, if you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh on June 7th of 2021?
Yes,
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital, was he there when you got there on June 7th?
no, he was not.
Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh's, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
Okay. And that's the time you were there?
Yes,
And you're never late, are you?
no,
And is somebody waiting to leave for you to get there?
yes.
Okay. And this night, who was there?
Was Miss Barbara Mixon, I'm thinking? Can't remember. I think it was Barbara.
I'm having trouble
I'm sorry.
understanding your words. Can you speak maybe louder?
Okay.
I
Yes.
know you can't change your voice, but
Yes, sir.
a little louder, please. Or closer to the mic.
Can you tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver, and this was what time of night?
8 o'clock that night.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No,
If they're sleeping, do you want to wake them up?
no.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, say,
You know, just come in with, you know, change her, if she need to be changed or whatever like that.
make sure that
She's
Dry.
She's dry, it's okay, yes.
and so where's your desk, or what's your position when you're there, when you're in her room, Miss Libby's room?
Yes,
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
in the recliner, have the recliner, sit there.
And is there a TV in the room?
Yes.
And is the TV usually on when you're there with Miss Libby in the evening, or does it?
Yes,
Okay. Was it on this night?
it was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Says, a game show.
Say it again?
American Says, the game show.
Okay. How long has that been on?
It's, stays on, it repeats, it's afterwards repeats itself.
What channel is that on?
The Game Network show. Channel, excuse me.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes.
Okay. Do you remember what time it was? Approximately.
The game show was on, so it had to have been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
It was somewhere up in there.
Okay. Is it fair to say it was later in the evening?
It was late in the evening, yes.
Okay. And you had worked that schedule for that 8 p.m. to 8 a.m. shift for how long?
2 years.
2 years.
2 years.
Was it unusual to see Alex Murdaugh at that residence that time of night?
Yes, on my shift. Yes,
And that's the only shift you'd work.
yes,
So the 8 p.m. to the 8 a.m. shift, it was unusual to see Alex Murdaugh there visiting, correct?
correct, yes.
Had you ever been over there before that time of night?
I think different off and on, it all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house.
Yes,
What phone did he call? It's a terrible question. I mean, was it your phone, the house phone?
the
I'm
house
not-
phone, the house phone.
And when you answered the house phone, what did he say?
He was outside. They let him in.
He was at the house,
Yes,
right outside the house,
yes,
and he called you,
yes,
and he said, "Let me in."
yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there at the house.
Yes,
You let him in?
of course, yes.
Okay. Do you remember what he was wearing?
Shorts
Okay.
and a t-shirt.
Do you remember what kind of shoes he had on?
Those cloth shoes, like Sperry's, that type of material. Like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, to me, yes.
And you said something called Spears?
Something like Sperry's, that, you know, that kind of, but it was cloth.
Okay.
That kind, yeah.
Wasn't boots?
No, it wasn't boots, no.
Are you familiar with tennis shoes?
Yes.
Was it tennis shoes?
No, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes.
Did he have any socks on?
No, no.
Tell the ladies and gentlemen of the jury, could you describe Alex Murdaugh's demeanor on June 7th when you were there with him and his mother Libby?
He just
How was he
came,
acting?
like, fidgety, this came in, you know,
Speak up, please. ma'am.
fidgety, I'm thinking, it's normal.
What did you say, man?
Like he was fidgety, like, yeah,
Fidgety.
yes.
Is that what you're saying? Okay. And did he tell you why he was there?
No, he just came to see his mother.
Did he talk to his mother?
But she was asleep, yes.
She was asleep? Okay. And what did he do? What did Alex Murdaugh do when his mother was asleep?
He came and sat on the bed, because we was asking me what I was watching. I said American Says, I said a game show.
Did he say anything to his mother?
We said, hey, Mom, how you doing? You know, just came to check up on you, yeah.
Did he say why he'd come to check up on her?
Because Dad was in the hospital, you know, call him Hansel, he was in the hospital.
And in your opinion, as being there, her caregiver, did she even know that he was there?
No,
The objection's overruled.
You said no?
no, mother, no.
How long did he stay in the room with y'all? When I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
No, he was laying on the bed,
Did he have his phone with him?
yes.
Was he looking at his phone?
Yes, he was on his phone, yes.
I'm sorry, ma'am. What?
Yes.
After that initial conversation, you said, he said, I'm here. Did he have any other attempt to have any other conversation with Miss Libby?
No,
Did he hold your hand out? Did he ever hold her hand?
yes, he did hold her.
hold her? Did you talk to her?
Yeah, she was in the bed, yeah, yes. he
And
did.
her condition then was what?
She was, you know, sleep off and on, sleep.
How long did he stay there? I forgot.
20 minutes, about 20 minutes.
$20.
About 20 minutes.
What happened after that?
He left.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Miss Mixon?
Yes,
Did you learn what had happened at Moselle?
yes.
At some point after that, did you get a call from a family member? I really don't know who it was, but did you?
Yes,
Do you remember who it was?
yes.
Okay, who was it?
This is Randy
Randy Murdaugh.
Murdaugh, yes,
Alex Murdaugh's brother.
yes.
And as a result of that, what was, were you expecting people to come over after that?
No,
After that phone call, were you expecting people to come spend the night that night?
Yes.
Okay, who? Who was gonna come over?
Randy told me, John Marvin, Buster and his girlfriend, and Alex.
John Marvin, Buster and his girlfriend, and Alex.
Yes,
And did you, and in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you gotten a call from Mr. Randy saying they were coming? Did they come?
yes, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No,
Did he ever come looking for glasses?
that morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
And Mr. Randolph, or Solicitor Randolph, died shortly, a couple of days after that?
Yes,
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
yes,
And were you happy to do that?
of course.
And do you remember the day of Mr. Solicitor, I'm going to call him Solicitor, that's the way I know him, Solicitor Randolph's funeral?
Yes.
In I've been reading through all this stuff here. What's a repast?
A repast is when everybody come back after the funeral to eat.
Everybody comes back and eats?
Yes.
Well, after the funeral, did people come to Alameda, sort of like a visitation after a funeral?
Yes,
Okay. Did folks come over there then?
yes,
And was the family there then?
yes.
And during this past visitation, where were you doing during the visitation?
I was in the room with Miss Libby. It was back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes.
Okay. Tell the jury about that, please.
He came in the room,
You'd speak up, please, ma'am.
he came in the room and speak that, spoke like he always do.
And what did he tell you?
That he was at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house? When?
The night of the murders.
The night of the murders?
Yes.
What was he telling you about that he was at the house the night of the murders?
That he'd been there 30 to 40 minutes.
Was he telling you that? Did he ask you anything about that when he was talking to you?
Yes.
Did he indicate to you what he wanted you to do with that information?
No, no.
What did he say?
He just said that he was at the house, the 30 to 40 minutes, I said.
You said what? Was he there 30 or 40 minutes that night?
Not to my recall.
Why are you crying, Ms. Smith?
Because they were a good family, and I love working there. And I'm sorry all this happened. They're good people,
He wasn't there no 30 or 40 minutes, was he?
No.
Can't lead the witness.
Did that conversation upset you?
Somewhat.
You upset right now?
Yes,
Did you call anybody about it?
my brother.
You called your brother after that conversation with Alex
Yes,
to tell him about that conversation?
yes.
And just to be clear, what was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know
I was here 30 to 40 minutes.
Not to pry, but I can't help it sometimes. What else was going on in your life right there?
Just working hours and hours.
You're whispering. I can't understand what you're saying.
When you gonna get married?
I was planning on getting married. I was planning on to.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes,
And when was that?
day afterwards, I'm thinking.
The day after this?
I'm thinking it was,
After
yes.
the conversation
Yes.
you just said? Where were you?
At Miss Libby, at the house.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, just let me know, because the wedding's gonna be expensive. I said, well, thank you.
The wedding's gonna be expensive?
He said, wedding's gonna be expensive. I said, well, thank you.
Did he offer to help?
Yes, he offered. That's the type of person, a good person.
And did he ever mention the wedding to you before?
No,
Did you mention that to him before?
no,
Did he have a conversation, anything else about your job? Were you working at the school?
yes, at the school, yes,
Did Mr. Murdaugh mention to you about your school and your position there?
yes.
Tell him what he said, please.
He said that, you know, if you need a position at school, you know, my good friend is there. I said, yeah, I know, worked at the school, the principal.
I believe you testified, did you help out more than just your regular shift the rest of this week?
Yes.
That week after
Yes.
the murders and Solicitor Murdaugh's death? Were you working full-time then, trying to help?
Yes.
Was school out then?
No.
So were you still going to school and helping?
Yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes.
Do you know how long it was, how many days after the funeral of Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning.
Say that again.
6:30 that morning.
And that had been a part of your regular shift, right? 8 to 8 a.m.?
Yes.
And did he call you and tell you he was coming?
No.
He didn't? Well, had he called you on June 7th and told you he was coming?
Yes.
And he was right outside the house?
Yes.
And this morning at 6:30, he did not call you?
No.
How did you know he was on the premises?
He knocked on the, by the bedroom, near the window.
Knocked.
Yes, on the wall.
Well, did you hear him say anything after that?
He said, I'm outside.
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir.
Never.
No.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex Murdaugh.
He came in the white, left in the white truck, came in the white truck.
Was there still funeral stuff's not in the world road? There's still funeral equipment in the yard?
Yes.
Like what?
The tent was still there in the big old building, they put the food in, had out there, yeah.
Like a food truck?
Yeah, food truck, yes, the camping.
And was that blocking your view some?
Yes, block my view, yes.
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
Yes,
Then what did he do?
came inside.
And was Miss Levy sleeping?
Yes, she was still asleep.
Okay. Did he go check on Miss Levy?
No, he didn't come in.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
And did he have anything, or was he holding anything?
He had a blue something in his hand.
Say that one more
A
time.
blue something in his hand, something blue.
A blue something in his hand. And can you show me how he was holding it?
Like this.
Is it all right if I touch it?
Yeah, that's fine.
How was he doing it?
Like this, like that.
Holding something like this?
Yes,
And what did it look like?
like a blue. Blue,
Was it vinyl?
it's like a tarp that you put on a car, you keep your car covered up.
Big thing.
Yeah, blue, yeah.
And was he holding it like this?
It was holding like this.
Could you tell if there was anything in it, or do you know?
No, I couldn't tell.
But not holding like this? Did he say anything when he walked in?
No,
What did he do when he walked in?
went upstairs.
Make course notes. States 230. 223, 222, 413, 412. At this time, without objection, I'll save the other two. I didn't call it.
They're admitted without objection.
You testified Mr. Murdaugh came in your Alameda residence that morning. This is States 223. Do you recognize that?
Yes,
What is that?
upstairs, going upstairs.
And is that where he went, Alex Murdaugh, that morning,
Yes,
carrying some blue thing? And this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house?
yes,
States 413. What is this?
that's the bedroom,
Okay, where in Alameda is this bedroom? First floor, second floor?
first floor.
Is this where Miss Libby stayed?
No,
And 412? Is that the same?
yes, same bedroom, yes.
We'll show you was marked 411. Don't call out the answer. This is States 411 for identification at this point. Do you see the blue object in the center?
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue,
Is it vinyl?
yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is States 411 we'd offer at this point.
Is that admitted?
Let me just, I don't know how to ask it except to ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay. Where'd you see it?
in the bedroom, that,
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize. Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes,
Did you you ended up leaving at some point that day, right?
yes.
When you came back the next day, was that there?
No, it
It
wasn't.
was gone.
Yes, it was gone.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no,
Did you actually see him leave the house after he went upstairs?
yes.
And where did he go?
Oh, I don't know. He just left outside and left.
Okay. Did he say, "Hey, I'm leaving"?
Yes, I'm going, yes.
Okay. And at that point, what did you think? Did you think he'd gone?
I thought he left, yes,
Okay. Did you see him after that?
yes.
Tell them where, please.
He came
That
back.
morning.
He came back to the house.
And how do you know that?
Because the blind was open, I seen him came through the driveway.
And what did you see him? Was he walking? Was he driving? When you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, if I'm not, what truck was he driving?
the white truck.
And whose white truck was that?
I'm thinking it was Mr. Reynolds. I thought it was his truck. He had the white truck also.
He had a white truck also? Okay. So when you saw, you testified Mr. Murdaugh coming back in a white truck, that was Mr. Randolph's truck?
Objection, Your Honor, please.
Whose truck was it?
I don't know.
Ma'am, you must use words as opposed to, or because we need to know exactly what you're saying. Say yes or no if you can.
Whose truck did you think it was?
Oh, that was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day, the same morning.
Same morning when Mr. Murdaugh was there?
Yes.
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone? Do you know where he went?
No,
And when he came back in this white truck, what did he do?
he got another truck,
How long was he gone?
probably about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there in the way, so I couldn't see it.
So that blocked your view.
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck.
Do
Black.
you know whose that was?
No,
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
they had like a little cut, a little cut or something,
And ma'am, I apologize, a little what cut?
like a little bruise or something.
Where was it?
It's like above his forehead,
Okay, I won't ask you to touch me, but can you touch yourself to show where?
right here, something right there.
Did it look fresh?
This looked like a cut, not, I wouldn't say fresh, but it looked,
Was there a video system in the house for either Solicitor Murdaugh or Miss Libby Murdaugh?
yes.
Can you tell them about that? Where was that? What was that?
It was in the Miss Libby's bedroom.
And how was that activated or operated, is better? Do you know?
No,
Was it on all the time or not?
yes,
And what color would it be if it was on? Was there a marker or a red and black or red and green?
those circles, yes,
And would there be times when that wasn't on?
yes,
And do you know who controlled it?
no.
Get the helmet. I'm going to show you what's marked 410. Do you recognize this?
Yes,
Okay. And does it relate to what we're talking about this morning as far as your location?
yes,
Mm-hmm.
Your Honor, 410, I believe without objection.
Says it relates, and
Her testimony, where she was that morning.
no objection.
It's admitted. Without objection, it's admitted.
Can you see this on your, you got a little thing up there? Do you mind coming down here? Judge, can she come down here? Yes. Very briefly, it won't be long. If you would stand there, so just so we don't block the jurors, please, just so Mr. Griffin can see. Is this a picture of what we refer to as Alameda?
yes,
And can you show where the, I guess I've called the main house? And I'm sorry we don't have a pointer. That's the main house. And you have to say yes for the record, please, ma'am.
yes,
And down here, I know it's hard to see. Can you tell what that is? Sorry. Can you point to the main house again? I think you blocked some jurors. I apologize.
right here.
Is that where you took care of Miss Libby?
Yes.
Okay. Now, down here, there's even a little O on it. Do you know what this is down here? Let me ask you this, what other buildings are on the property?
The smokehouse and a barn, another little shed
And where were the ATVs usually?
at the smokehouse.
Where's the smokehouse?
That's it right there.
There you go, that's the smokehouse. And that's where the ATV
Shed.
was.
Yes.
And where did the ATV end up when you saw it after you thought Mr. Murdaugh left? Had it moved?
At the main house.
Say that again, please,
At the
ma'am.
main house.
Okay. And when you saw him coming back, you thought he left, where did you see him in the white truck? Do you remember?
He left him across the railroad track, you know. He left him across the railroad track and went out.
Which way to railroad tracks?
This way, I mean, that's the house. So it had to been around because I had to drive through.
You're not going to say anything, but speaking up.
I'm trying to.
That's good. Go back and sit down. That's
Until I
fine.
couldn't
Thank you.
see.
Now, have you talked with either Mr. Griffin or Mr. Harpootlian or one of their investigators?
Yes.
Okay, when was that?
Oh, God, I can't remember.
Best you remember. I'm not looking for a date and time, but you know how long we got?
It was last year.
And I met with you a couple of weeks ago,
Yes,
and just a little while ago this morning.
yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
Okay. And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes.
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in? Is that him?
Yes.
Thank you, that's all.
Good afternoon, Ms. Smith.
Good afternoon.
We have met once or twice. Did anyone ever show you a blue rain jacket?
No, no, yes, yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket,
Yeah,
correct?
picture of it, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No,
Now, you saw Mr. Alex Murdaugh bring a tarp in, you said, right?
yes.
And I'm going to show you a tarp, which we marked for identification. is this the type of tarp that Mr. Murdaugh came in to the Alameda house on the day that we're talking about?
Yes,
Tarp like this that would maybe cover up a car, is that right?
yes,
Any way to confuse this with a rain jacket?
no,
He was not carrying a rain jacket, was he?
no, it was balled up, I don't know him.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up, is that right?
Correct,
Have I balled it up sort of correctly?
yes.
All right.
No, we have no objection to that going in.
Your Honor, move Exhibit 86, I think, into evidence.
Without objection.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
Yes,
Okay. And you had, and when you left for end of your shift that day, that's where it was, right?
yes,
And you've never seen it since, correct?
correct,
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
no. In the
Do
closet,
we have that picture? What's the last photograph that went down? Can you see that, Ms. Smith?
yes,
Do you know where that is in, or even if it is in Ms. Libby's house?
I couldn't say because I don't be in the closets. I don't know,
So you don't even recognize the closet, is that right?
correct,
And have you ever even been upstairs in Ms. Libby's house?
twice,
2 times over how many years?
3 years,
2 times in 3 years. And do you know where Alex Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
no,
Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral, is that right?
yes,
Okay. And it was early in the morning?
yes,
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
yes,
So then it would be Monday, Tuesday, Wednesday of that week, is that right?
yes,
Okay.
that's correct,
And is that the morning that you said that you thought you saw a bruise on his forehead?
yes,
So it was Wednesday after Mr. Randolph's funeral?
I'm thinking, I can't remember, it was so long, I can't remember.
Yes, ma'am. And and you mentioned that that he came in a truck. I think you said he drove up in a white truck. Mm-hmm. Is that correct?
Yes,
And he does have a white truck, as
Yes.
far as you know, right?
yes,
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alex's truck that he left in?
because it was moved, Mr. Randolph had always keep his truck in a certain position, certain part,
So you think he left in Mr. Randolph's truck and moved?
yes,
Okay. And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway,
yes,
parked in its normal place?
yes,
Anything out of sort?
no,
Was it all covered up with mud, like someone's been mudding in it?
no,
Anything unusual about the truck?
No.
Now, you mentioned there was a four-wheeler that had been moved at some point in time. That four-wheeler had a flat tire, didn't it?
Yes, it did.
Okay, was it a front tire, back
I
tire?
think it was a back tire.
And it was moved up close to the house,
Yes.
as far as you know, so the tire could be repaired?
Yes, it was moved from the smokehouse to the record house, yes.
With a flat tire?
Yes, with a flat tire.
Now, you asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes,
And he said he was there 30 to 40 minutes.
yes,
And you said, no, I don't think it was that long.
yes,
And then the next day, I think you said, or day after, well, the following day, or I guess it would have been a Monday, you had another conversation with him where you just brought up back that you were going to get married. I think you said that was a different day, right?
yes,
And he was just being nice, wasn't he?
yes.
And I think you used the word good person.
A good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Now, he came over on the night of June the 7th, and you said it was somewhere between 8:30 and 9:30 in the evening,
Yes,
and that's just your best estimate of when he got there, is that right?
yes,
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
yes,
Now, when you said 15 to 20 minutes, are you talking about 15 to 20 minutes in the room with Ms. Libby, or on the property the whole time?
and probably the whole time, thank you.
Okay, well, now, you said it took you about 5 minutes to let him in, is that right?
Yes,
So, are you including the 5 minutes it took him to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes, I don't think that's
No.
the whole time, so.
And you would agree that Alex Murdaugh would visit his parents frequently, right?
Yes,
And he would always come over more so than any other sibling, is that right?
yes,
And you would agree that it was not out of the ordinary for Alec to come at night, correct?
yes.
You would agree with that, right?
No,
So you don't agree that is, so was it out of the ordinary for him to come at night?
yes, on my shift, yes,
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? You remember that?
yes,
And do you remember telling him that it was not out of the ordinary for Alec to come at night?
yes, it's been long, and I couldn't remember, it's been a year now, so I can't really remember.
I mean, is it possible that you told him that?
Yes,
And here today, you said, as I have in my notes, that when he came over, that he was acting kind of fidgety, yet normal. I believe that's what you said. Is his normal behavior kind of fidgety?
yes,
He's just kind of a fidgety person, right?
yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
But he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes.
Okay. Now, you mentioned the clothes that he was wearing, and he came in and he sat on his mom's bed,
Yes.
lay down next to her,
Laid.
and held her hand. Is
He
that
walked
right?
in, walked in and hold her hand and spoke to her, then went on the bed and lay down.
And lay down.
Not lay down, but sit up.
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall, but I didn't touch it.
Okay. What did Alec Murdaugh have blood on his clothes?
No. I
He
didn't.
had blood on his shoes.
No,
He had blood on his hair.
no,
Did he leave blood in his mom's bedroom?
no.
Now, according to the records that we've been provided in this case, you were interviewed by SLED on June 16th. Do you remember that
Yes.
interview?
Yes,
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes.
Okay. And then you were interviewed again by telephone on June 17th. Do you remember that follow-up call? You remember having a short phone call on the 17th?
A phone call.
Okay. Well, whether it's one interview or two interviews, you never told anybody at SLED in June, in these interviews, one or two, anything about Alec coming in with a blue tarp, is that right?
Right.
You didn't say anything about a blue tarp until sometime in September, is that right?
Yes.
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale Police Department when he was working a wreck. Do you remember that? Mm-hmm. Is that yes?
Yes,
Okay. And you had been in the automobile accident, and Officer Dingle was working the wreck and I guess filling out an incident report, and you were having a conversation with him.
yes.
And in that conversation with Officer Dingle, didn't you tell him didn't you tell Officer Dingle that on the night of the murders that Alec came over with a blue tarp that looked like it had a gun in it?
No, I saw him like he was holding something.
So you didn't say,
I didn't say specific was a gun, I said he was holding something.
so you didn't tell Officer Dingle that he came over and you couldn't tell, but stated it looked like a rifle?
No, I said it was like he was holding something. I did not say it was a rifle.
Okay. And if Officer Dingle wrote a report up saying that, he was just incorrect?
Yes,
Okay. And then after you had this conversation with Officer Dingle, then you were contacted by SLED agents, right? Mm-hmm. And they asked you to go down to their offices, and that's where you were interviewed in September, right?
yes,
And in that interview, you told them about a blue tarp that you'd put over your car, just like this, right? Is that correct?
yes,
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle?
right.
Okay. And since that day of the interview at the Low Country SLED office, have you had any additional interviews with SLED agents other than getting ready for trial last week?
Yes,
How many additional interviews?
two or three.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alex Murdaugh walking into the house with?
Yes,
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
and it was balled up as a blue tarp.
Because you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes, yes.
One second, Your Honor. Just one more point. When Alex Murdaugh came over on that early morning, I guess it was Wednesday, you testified, were you in Ms. Libby's room?
Yes,
And you can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you? You can?
no.
Okay. Thank you, Your Honor. That's all the questions I have.
Redirect.
Testifying in front of the grand jury on January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total, do you remember that?
Yes,
Do you remember your answer being 20, 10, 15, 20 minutes?
yes.
Mr. Griffin asked you about the 30 to 40 minutes. Why'd you call your brother after that?
Because he's a chief, assistant chief police at Varnville, so I called him.
Had that statement by Alex Murdaugh affected you?
Yes,
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No,
And his 9:30 visit the night of the murders, that was very unusual for him to be at night, wasn't it?
Objection, leaving.
Don't leave the witness.
I'm sorry.
yes,
Was that unusual?
yes.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying
Yes,
before you told anybody else?
yes.
And what was that about, a traffic accident?
I had someone hit my car, and he was on duty,
And when was that?
September 11th.
That's my birthday. You had an accident, and you told the officer that you had seen him, Alex Murdaugh, come in holding something?
We was talking, we was having a conversation, and that came up.
And you just told him that?
We was talking.
Had anybody asked you that before? You have to say yes or no.
Yes.
Had
No,
anybody asked
no,
you that before?
no.
Okay. So why did you tell the officer that on September 11th?
We was having a conversation, and just talking in general, and he asked me a question, and I said, yes, I've been there, and I said, I work with the Murdaughs. To keep, his mother.
In response to him, you told him you saw Alex Murdaugh with what?
A lining, a blue tarp,
And you saying tart or tart?
tarp, like you cover a car with a tarp,
And you said you saw him with that, and did it appear he was carrying something?
like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes,
Like this?
yes.
So you never saw this unfolded?
No, I never saw him
Never.
till the next morning. That was on the chair in Miss Biggins' room.
And you don't know where this tarp came from, do you?
No, I don't know where it's coming from.
And it didn't have silver on one side, did it?
No,
It was all blue.
all blue.
And you said that the defense took a statement from you?
Yes.
Did they record it?
Yes.
Your Honor, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking the stand.
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, I think. Once the witness has taken the stand and she said that they took the statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
The rule says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
Your Honor, we do have a copy here. I don't know if we can download it to, you got it?
Is it okay to produce it on flash drive? Judge, I mean, I can't look at a flash drive, but yeah, I guess. Is it a hard copy?
Not a written statement, it's an audio recording.
I'd like to have an opportunity to listen to that without the presence here. I would assume it'd be a hard copy, but I don't want to mess the court schedule up either.
Now, ladies and gentlemen, we'll have you go to the jury room. Please do not discuss the case.
But tell me you got a written transcript.
We'll be at ease momentarily.
Please be seated.
Well, let's see, if you need a half an hour to listen to this tape, we can take.
Your Honor, we have a rough draft of a transcript that we're emailing to them, but it's 57 pages long, but we're sending it to them.
A rough draft.
But I'd like to look at the video at this point.
All right, we're going to bring the jury in and break for lunch. All right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30, till 2:30. And this is jury number. Juror number 729, I'll speak with you during lunch. So you can return to the jury room, please. We're going to take a break for lunch. You just cannot discuss your testimony with anyone during lunch, but you can step down and have a good lunch. And we will be in recess till 2:30.
Please be seated.
As council may recall from during jury selection, juror 957 expressed a concern about being here if the trial goes too long, and he mentioned 3 weeks as his limit. So he's brought that to my attention, and he's 729, juror 729. So he's brought that to my attention, and he's pondering the issue. So just bring you all up to date on that issue. You ready for the jury?
I just want to raise one issue.
All right.
It doesn't relate to this witness, but the next group of witnesses the state intends to call relate to this blue rain jacket, and that it was seized as a result of a search at Ms. Libby Randolph's Murdaugh's house, and it was found in the closet. Based on what this witness had previously shared with law enforcement, there's no evidence that we've been provided in discovery that connects the defendant with this blue rain jacket. And so we moved to exclude any evidence of the blue rain jacket unless they can represent to the court that they have any witness who connects the blue rain jacket with this defendant, Alex Murdaugh. Thank you.
All right. From the state?
Your Honor, she has identified a vinyl blue in that closet, which she says was consistent with what she saw Alex Murdaugh coming into her house with. She said, yeah, that looks like it. There's some questions that were asked by the defense, which I'm going to ask her about now, when she is asked about a shirt and something else, but she, I believe, has testified, yeah, that is consistent with the color and the vinyl that I saw that's in the closet.
All right. Well, let's bring the jury. All right, thank you. You may proceed, Mr. Meadows.
Your Honor. Smith, do you remember being interviewed by Patrick McDavid and Robert Purcell that worked with Mr. Harpootlian and Mr. Griffin in October 20th of 2022?
Yes,
And I believe Mr. Griffin had asked you about some shoes in response to our questions. Do you remember telling them that he had, these investigators, he had on some cloth-like shoes?
yes,
And I believe Mr. Griffin asked you about the length of time you were there. Do you remember these investigators asking you about the length of time that Mr. Murdaugh was at Alameda the night of June 7th?
yes.
Objection, Your Honor. he's offering a prior consistent statement, and no one's I don't know why. Not impeaching her with it. You can't bolster her testimony with prior consistent statements.
Mr. Mitters?
I believe he had questioned the 30 or 40 minutes and was questioning whether or not Alex asked her to say that. Through their investigators, it's clarified for me their conversations that directly contradict what she said early on direct, that I have through their questioning and interviews, which I just got a little while ago.
All right, Mr. Griffin?
Again, he's offering a prior consistent statement, and it's not admissible unless it's being offered to rebut a claim of recent fabrication, and that's not the situation we have here.
The entire statement right now.
Any objection to the statement being entered into evidence?
Yes, Your Honor, it's not a statement. There's a whole 30-minute audio recording. Yes.
All right. Rule 613B addresses this issue, and you may proceed. The objection is overruled.
Mr. Griffin asked you the length of time that Mr. Murdaugh was there when these investigators questioned you in October of 2022. Do you remember them asking you about how long he was in the kitchen and in the room with Ms. Murdaugh?
Yes,
And do you remember them asking you about, and he asked you on cross, whether it was unusual, whether Mr. Murdaugh had visited that time of night? Do you remember that?
yes,
And do you remember telling the investigators that he would not come on your shift after 8 o'clock? Do you remember that?
yes,
And that that was unusual?
yes,
And do you remember one of them questioning you, you actually registered it in your mind that this is unusual for him to be here that time of night? Do you remember that?
yes,
Was your answer, yeah, because I was like, yeah, to be honest, I was like, oh, why are you here this time of night? Why are you here this time of night, you know? Because we all going to bed?
it's in my mind. Yes,
And as far as the length of time, do you remember them asking you how long, and you said it was about 20 minutes?
yes,
You know, and I'm trying to speed this up, maybe for some indulgence. Do you remember, when Mr. Griffin asked you about your recollection as to what Mr. Murdaugh said asked you about the 30 to 40 minute period? Do you remember that? Remember just a little while ago when he was asking you about that? I'm not trying to be, just a little while ago.
yes,
Okay. About whether if anybody ever asked you if I was here or not?
yes,
And do you remember that his investigators asked you if SLED had put that in your mind?
no,
Is that the recollection or something they put you in?
He's leading the witness, he's publishing a document that is not a certified transcript of anything. I object.
Mr.
It's their statement they took.
I sustain the objection.
Did Alex Murdaugh ask you to tell somebody how long he'd been there?
He said, if someone asks you, I've been 30 to 40 minutes, that's what he said.
He said if somebody asked you.
Yes.
Just repeating her answer.
Mr. Metters?
Is that the answer you gave his investigators
Yes.
back in October of 2022?
Yes.
And do you remember one of them questioned you, you actually registered it in your mind that something, that this is unusual for him to be here that time of night? Do you remember that?
Yes.
Was your answer yeah? Because I was like, yeah, to be honest, I was like, oh, why are you here this time of night? Why are you here this time of night, you know? Because we all going to bed?
It's in my mind. Yes.
And as far as the length of time, do you remember them asking you how long? And you said it was about 20 minutes?
Yes.
You know, and I'm trying to speed this up. Maybe court's indulgence. Do you remember, when Mr. Griffin asked you about your recollection as to what Mr. Murdaugh said asked you about the 30 to 40 minute period? Do you remember that? Remember
Yes.
just a little while ago when he was asking you about that? I'm not trying to be, just a little while ago.
Yes.
Okay. About whether if anybody ever asked you if I was here or not?
Yes.
And do you remember that his investigators asked you if SLED had put that in your mind?
No.
Is that the recollection or something they put you in?
He's leading the witness, he's publishing a document that is not a certified transcript of anything. I object.
Mr.
It's their statement they took.
I sustain the objection.
Did Alex Murdaugh ask you to tell somebody how long he'd been there?
He said, if someone asks you, I've been 30 to 40 minutes, that's what he said.
He said if somebody asked you.
Yes.
Just repeating her answer.
Mr. Metters?
Is that the answer you gave his investigators
Yes.
back in October of 2022?
Yes.
Now, Mr. Griffin asked you about this blue tarp. Did his or Mr. Harpen's investigators ask you about that when they met with you?
Yes,
Did they bring something with them? Do you remember them showing you something?
no, a picture,
Okay. Did they also show you a tarp?
yes,
Okay. Did they tell you they just got it from Kmart?
yes,
Just bought it from Kmart? I can't. So their investigators brought this with you to the interview
yes,
and showed you this, correct?
yes,
And had you already described a, well, who'd you first tell that there was something that the defendant may have been holding in his hand? Who'd you tell first? When he came in that morning after the funeral, who did you tell that first to in law enforcement? That the defendant may have been holding something or was holding something when he came in?
Dango, Officer Dango,
Dango.
Dango.
Okay. And as a result of that, Sled came and interviewed you?
yes,
Okay. And then you told them what your testimony's been?
yes,
Correct? Okay. So in October of 22nd, when their investigators came, they were asking you about what you talked about to Dango, right?
yes,
Okay. And they showed you this, right?
yes,
And did they also ask you about if you'd seen a shirt? Do you remember when they asked you if you'd seen a blue shirt?
yes.
What was a blue shirt?
It's a blue,
Well, I don't know. What was it? Just like a dress shirt or a shirt? What was it?
like a rain jacket or something, like a pullover,
Okay.
something.
But they described it as a shirt?
No, not as I can recall.
Do you remember them asking you, you're positive it wasn't a shirt?
Yes,
They
Yes.
asked you that?
yes,
And your answer was it's vinyl. It was a vinyl, right?
yes, yes,
Don't lead the witness.
And Mr. Griffin was asking you about the vinyl, whatever. Do you remember them asking you if there could have been a gun in it, his investigators?
I can't recall, I can't remember.
Last question, Judge. I had that picture. States 411, Ms. Shelley. You've identified this previously. Does that look like the blue vinyl garment he was carrying in?
Yes,
Say that again.
yes,
Was it all crumbled up in his arms?
it was balled up, yes. balled
Was
up.
it folded out?
No, it wasn't.
Was he wearing it?
No, he wasn't.
That's all, thank you.
By the defense.
Ms. Smith, it's clear when you left the next morning, you saw the blue tarp laid out on Ms. Libby's retirement rocking chair, correct?
Yes,
And it was not a rain jacket, was it?
no, it wasn't.
It was a blue tarp, like what's in here as in evidence 86, right?
Yes,
No doubt in your mind.
no doubt.
Now, our investigators, let me ask you, marked for identification exhibit 87, did they show you a picture of this rain jacket?
Yes,
Had you ever, and you told them you never seen that rain jacket, right?
correct.
Your Honor, we'd introduce exhibit 87 in evidence.
Without objection.
Can I put it up here? Well, while they're working on that, Ms. Smith, did anyone speak to you over lunch about your testimony?
No,
Did you talk to any SLED agents or anybody at the AG's office?
no.
Trying to get that going. Is that full size? Yeah, let's see if we get the whole picture in there. Okay, thank you. Thank you, Doug. Have you ever seen this rain jacket before?
No,
Did Alex Murdaugh have that rain jacket with him when he came in to the Ms. Libby's home on the morning, I believe, a few days after the funeral?
no,
Okay. And if this photo, Exhibit 41, states Exhibit 41, can you see this blue thing wadded up?
yes,
If that is, in fact, the photo of the rain jacket that we just looked at, would your testimony be you've never seen that garment folded up in that closet before?
no, only thing I seen was blue velvet. I didn't know it was a raincoat or not. It was balled up.
So well, had you ever been in this closet before?
No, I haven't.
So you don't know what that is folded up there, do you?
Correct?
And so if it's this rain jacket, if that's what's in that closet, you've never seen Alex Murdaugh with this garment before, have you?
No, I haven't.
All right. Now, just very briefly, I know you've been really good here. I know it's been a hard day, and we appreciate you being here. That day when you came to work, Mr. Randolph Murdaugh had been put back in the hospital. Is that correct?
Yes,
And that was unusual because he'd just gotten out of the hospital like a day before, right?
yes,
And so it was, although it wasn't usual for Alex Murdaugh to come over that night, but this was an unusual day because Mr. Randolph had been put back in the hospital. Would you agree with that?
yes.
All right. Thank you. That's all the questions I have, John.
Thank you, ma'am. You may step down. You may call your next witness.
The state calls Kristen Moore.
Raise your right hand and left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? I do. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Kristen Moore. Moore. Good afternoon. Good afternoon. Could you tell the jurors where you work?
I work for the South Carolina Law Enforcement Division.
And Agent Moore, you might need to pull that microphone a little, speak up so we can hear you, make sure to hear you out here. Thank you. And what do you do with SLED?
I'm a special agent assigned to the crime scene unit.
And did you have an occasion to become involved in the investigation of the murders of Paul and Maggie Murdaugh?
Yes, ma'am, I did.
Were you involved in the execution of a search warrant?
Yes, ma'am.
And where was that search warrant executed?
At 2175 Yemisi Highway in Barnville, South Carolina.
And do you know what that residence was or is?
It was the residence of Alexander Murdaugh's mother.
And who was there when you executed this search warrant?
Several SLED agents were on scene as well as family members.
What were you looking for when you searched the residence?
We were advised that we were looking for a blue and colored tarp-like material.
And what areas of the residence did you search?
We searched the entire interior of the residence.
Let's talk about the north bedroom of that residence. Do you recall what you located in that bedroom?
We located a blue tarp inside the closet in the north bedroom on the second floor.
I'm going to show you what's been marked as State's Exhibit 224. Do you recognize what's in that picture?
Yes, ma'am, I do.
Is that a fair and accurate representation of what you found in the north bedroom closet?
Yes, it is.
Your Honor, at this time the state would move States 224 into evidence.
Admitted.
Permission to publish?
Yes.
Agent Moore, could you describe for the jurors what you found in that picture?
That is the blue tarp that we located inside the bedroom in the inside the closet inside the bedroom.
Okay. And what was that tarp located in?
A storage container.
Were there any items in the storage container?
There were miscellaneous dishes underneath the tarp.
After you found the tarp, did you continue searching the residence?
Yes, ma'am, we did.
Okay. And what else did you find?
We located a blue raincoat in the coat closet on the second floor.
I'm going to show you what's previously been entered as State's Exhibit 223. Do you recognize that photo?
Yes, ma'am, I do.
They put that on the screen so the jury can see. Could you point out that closet for us?
It is at the top of the photo on the right-hand side. So the door immediately above the stairs leads to an attic area, and the door to the right of it is the coat closet.
So not this door right here at the very top of the stairs. The next door is the closet we're talking about.
That's correct.
And I'm going to show you tapes 414. Do you recognize that picture?
Yes, ma'am, I do.
Okay. And what are we looking at there?
That is a picture of the interior of the coat closet.
Your Honor, at this time I move states 414 into evidence.
No objection.
So admitted.
Now, Agent Moore, if you could you point out the blue raincoat or tarp-like material that you found in this picture?
It's in the back of that photo behind the white box, towards the bottom.
And if you don't mind, would you mind stepping down and pointing that out to the jurors? Okay. Would you come down to the big TV? Thank you.
It's right here.
So, and that's how you found the raincoat?
Yes, ma'am, it is.
Jammed down in that closet?
Yes, ma'am.
And if you look at this picture, it appears there are other items of clothing that are hanging up,
Yes, ma'am, there was.
but the raincoat is balled up down there.
That is correct.
And what did you do when you located that raincoat?
We documented it with photographs, and then we collected it in a brown paper bag, which was dated, sealed, and initialed.
I'm going to show you states 225, which I believe the defense has an objection to.
Your Honor, if this is the raincoat, it's already in evidence. And the photo of the raincoat is in evidence. I don't know why we need another photo, but we do object to any testimony about seizing the blue raincoat, anything beyond that, based upon my earlier statements to the court.
Response?
Your Honor, this agent's testifying to what she retrieved from the closet, and I believe this is a picture of her retrieving that item.
Objections overruled.
So, Agent Moore, do you recognize what's in this picture?
Yes, ma'am, I do.
And this is a true and accurate depiction of what you recovered from that closet?
Yes, ma'am, it is.
Your Honor, at this time I would move states 225 into evidence.
Objection.
Same objection.
Submitted over objection.
All right, and Agent Moore, if you could tell us what is in this picture, States Exhibit 225.
That is a photo of the blue raincoat that I collected.
And this will be States Exhibit 226. Without opening this, can you tell us what is in this item, States Exhibit 226?
Based off of the item number and lab number and my initials, this would be the blue raincoat.
Your Honor, the state would move States 226 into evidence.
Objection, relevant.
Response?
Your Honor, this is the purported raincoat that was recovered from the closet.
Submitted.
All right. And when you recovered that raincoat, what did you do anything with it besides photograph and collect it?
Not on that day. We transported it back to the SLED Forensic Services Laboratory.
And now in the closet where you found that raincoat, were there any guns?
No, ma'am.
Were you involved in any of the processing of the raincoat?
Yes, ma'am, I was.
And what part were you involved in?
On October 7th, 2021, at the SLED Forensic Services Laboratory, I met with SLED serology personnel to document and do additional processing on the raincoat.
Okay. And what processing did you take part in?
It was documented with photographs. The stains on the raincoat were then documented with scale tape and labeled, photographed again. SLED serology department then tested the stains with phenolphthalein, which is a presumptive test for the presence of suspected blood. All testing with phenolphthalein was negative. We then used an alternate light source to look for any latent stains on the raincoat. We observed an additional stain and documented it with photographs as well as scaled it. Then it was tested with phenolphthalein as well, and it was negative. We then used leucocrystal violet, or LCV, which is also a presumptive test for the presence of suspected blood, and it was negative also.
All right, as far as your involvement in the raincoat, does that pretty much sum it up for us?
Yes, ma'am, it does.
All right, thank you, Agent Moore. Please answer any questions from the defense.
Good afternoon, Agent Moore.
Good afternoon.
So I understand you went to Almeda, Ms. Libby Murdaugh's home, to execute a search warrant, is that correct?
Yes, sir, it is.
And what was the day? September
September 16th, 2021.
16th, 2021. And you were looking for a blue tarp,
We were advised that we were searching for a blue tarp-like material.
okay? And you found a blue tarp, is that right?
Yes, sir.
And in that blue tarp, there were dishes wrapped up in that blue tarp, right?
No, sir, no dishes were wrapped in the blue tarp. It was folded on top of the dishes.
Okay. So you seized the blue tarp, right?
Yes, sir.
And did you do any testing of the blue tarp to see if there was blood?
No, sir, I did not do any testing on the blue tarp.
Do you know anyone who did any blue testing on the blue tarp?
I am unaware of any testing done on the blue tarp.
You seized this rain jacket in here, in this box, is that correct?
Yes, sir, it is.
And back in the lab, you did some presumptive testing. We sprayed it with phenol first?
Phenolphthalein was first utilized, yes, sir.
And phenolphthalein is a presumptive test for blood, meaning, you know, it could test positive, but it's not necessarily means it's blood, right?
That is correct.
And in order to determine whether something that has tested positive with phenolphthalein, you do another type of test to confirm human blood, right?
That is correct.
But the blue rain jacket never tested positive for the presumptive test using phenolphthalein, right?
That is correct.
So it was negative.
Yes, sir.
So after getting negative with phenol, then you used another product called LCV. Is that right?
We did. We used an alternate light source first to make sure that we had all stains documented.
Now, an alternate light source is what?
It is a specific wavelength of a flashlight, and you used a colored filter, and then you can see any latent things that you wouldn't be able to see with your naked eye.
And the alternative light source doesn't tell you whether that's possibly blood or something else, does it?
No, sir, it does not.
So you use that alternative light source and you identified some area, and is that the area you tested with LCV?
We tested the entire raincoat with LCV.
The entire raincoat? Okay.
Yes, sir.
And again, that's a presumptive test like phenolphthalein,
Yes, sir.
and that tested negative?
That is correct.
Okay. And so there's no more blood testing done of the rain jacket, right?
I was not involved in any further processing of the raincoat.
Do you know if that LCV that you sprayed on the entire shirt has turned the rain jacket in that box completely violet?
I have not seen the raincoat since the processing was done on October 7th, 2021.
Okay. What size is this rain jacket?
I could not tell you the exact size of the raincoat.
Well, would you agree with me that the records indicate it's a large?
Yes, sir, it is a larger jacket.
Well, the size being large, do you know if it's large? If that's the size?
I do not recall the size.
Do you mind if she opens it up? Your Honor, do you mind if the witness opens the box up and let's see what size the rain jacket is?
Any objection?
No objection, Your Honor.
I have scissors.
You have scissors?
No, I don't have scissors. I have gloves.
Any gloves?
Yeah. I don't see a tag right here at the front. You may want to put gloves on. It has chemicals on it.
Oh, I don't want to touch it then, which I just did, okay. Well, do you mind standing up in front of the jury and show them how large it is? Is it a poncho style rain jacket?
Yes, sir, it appears that way.
All right, thank you.
Thank you.
Smells too good. Do you know if that rain jacket or photos of that rain jacket was shown to any members of the Murdaugh family to see if they recognized it?
I am unsure.
Okay. You did not then, did you?
No, sir, I did not.
Did you show that photo or picture, excuse me, the photograph, the rain jacket? Let me scratch that. Did you show to Shelley Smith the rain jacket or a photo of the rain jacket?
No, sir, I did not.
Do you know of any sled agent who did?
I do not.
1 second, Your Honor. That's all the question I have.
Further questions?
I only brought this up there.
All right, Agent Moore, what happened to that tarp? Or raincoat? Where is it?
It's in the
back
box.
in this box?
Yes, ma'am.
Okay. All right. State's Exhibit 226. This is the raincoat you collected from that closet at Alameda.
Yes, ma'am, it is.
Now, when you collected it, did it have like this tape here on the raincoat? Where we can, the white tape with the letters on there?
No, ma'am, I placed that on that.
So that was done during processing?
Yes, ma'am, it was.
And we've been talking about a raincoat, but this isn't, is this what you would normally think a raincoat would look like?
No, ma'am.
This is rather large for a raincoat.
Yes, ma'am.
When you found it, it was balled up like this?
That is correct.
No further questions for this witness, Your Honor.
Thank you. You may step down.
Thank you.
Call your next witness.
William McElby.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court shall be the truth, so help you God? Take a seat in the witness stand. State your name again. Spell your last name.
My name is William McElveen, M-C-E-L-V-E-E-N.
Mr. McElveen, how are you doing today?
Doing well, how are you?
Doing well. If you would, tell the jury a little bit about yourself. Where'd you grow up, and where'd you go to school?
I grew up in Columbia, South Carolina. Went to AC Flora High School. Went to the Citadel after high school. Graduated there in 2017. Went to get my master's at Clemson. Graduated in 2018. Moved back to Charleston, worked for a CPA firm for a while. And now I'm in finance for a home builder.
For where, sorry?
For a home building company.
And what area generally do you currently live?
Live in Charleston now.
Mr. McElveen, were you friends with Paul Murdaugh?
I was good friends.
All right, well, tell us a little bit about when y'all first met.
So I lived in Edisto Beach every summer with my granddad, and when I was growing up. And he was in Edisto all the time, so we just became close. Edisto's a small town. Not many young people live there, so the young people kind of stick together. We both love fishing, hanging out, so we just became good friends through that.
So you would spend the summers in Edisto?
That's correct, yep.
And what kind of things would you do throughout those summers?
Just hang out, work, fish.
What kind of jobs did you get?
I worked multiple jobs there for 5-ish summers. Worked at the marina a good bit, a restaurant there called the Sea Cow. I worked at a realty company as an inspector, and at the Bilo as well.
Okay. And I think you just said, but you met Paul about the high school years?
That's correct.
Okay. Tell us a little about your friendship. How did it start, and how did it kind of evolve?
It started just kind of common interest in fishing and hanging out, and then he was just a really fun guy, so we just hung out more and more. And I started going to Moselle, hanging out with his whole family. They kind of took me in and just evolved from there. Yeah.
So did you get to know him pretty well?
Yes, I did.
Did you get to know his family fairly well?
Yes, I did.
Tell us a little bit about Paul.
Paul was just a really fun guy, just like life of the party kind of guy. Everybody that really knew him loved him. I don't know, just a great guy, very loyal friend, the kind of guy that's always there when you need him.
So he was, if you reached out and needed something, he... You might want to pull that mic a little closer to your mouth so it picks it up. Just try to speak into the microphone.
Okay.
So was he sort of a responsive friend, meaning if you reached out to him, would he respond back?
Yes, he was very responsive.
And how did you primarily communicate with him? What means?
Cell phone normally.
Phone calls or text?
A little bit of both, but mostly phone calls. He was a big phone caller, I guess.
Well, I guess tell us a little bit about Paul's cell phone use. Did he like to use his cell phone?
He did like to use a cell phone.
How would you describe it, his use of cell phone?
He used cell phone a lot. Like kind of every time he had a road trip or anything like that, he would use it to call all of his friends and just check in on everybody. And I can speak for almost all of his friends. We get a phone call from him almost every day. And then he used text a lot, Snapchat, that kind of stuff.
Was he on his phone quite a bit?
Yes.
To the point where was it very noticeable to his friends?
Yes.
Did you ever have did you have an opportunity to get to know Maggie Murdaugh?
Yes, I did.
All right, well, tell us about her. What was your observations about her, or your whatever friendship y'all had?
She was just a super sweet lady. She kind of always trusted Paul when he was with me, because she would know he's staying out of trouble. She just treated all Paul's friends like they were her kids. And just a very nice lady.
And did she approve of you hanging out with Paul?
Yes.
Okay. Tell us about that.
About what, sorry?
Well, did she ever comment to you about how she liked you hanging out with Paul?
Yeah, she did. Like hang out with Paul.
And did you have an opportunity to get to know Alex Murdaugh?
I did.
All right, and what were your perceptions of him?
Kind of the same way the rest of the family, just took everybody in, all Paul's friends. He was kind of the dad of all of our friend group. Same way the rest of the family, yeah.
And is he here today?
Yes,
Did you identify him?
yes. It's in the brown jacket.
Thank you. Did you ever get to go out to the family property on Moselle?
Yes, I did.
How often would you have you been out there visiting?
Probably 30 or 40 times.
Okay. Did you spend the night when you went out there?
Yes, normally.
Tell us a little bit about the property. What kind of things would y'all do out there?
Did a lot of hunting, also probably more than hunting, just hanging out. Just enjoying each other's company, hanging out.
So you said about what, 30 to 40? Is that what you said?
That's correct.
Okay. If you would, please
Yep.
speak up a little bit. It's okay. All right. Now at the property, was there a main house location?
There was, yes.
All right. And was there a secondary location for kennels and a shed?
Yes, there was.
All right. Did you spend much time out at that secondary location?
A good bit, yeah.
All right. Describe that area for us, if you would. What was out there, and what would you do out there?
So it's like a big shed hangar that side comes up. We'd all hang out over there. And there's the dog kennels. And then a few years back, they built the shed across from the hangar. And it was just a good place to get away from the main house and just hang out and talk.
If you were visiting Moselle, would you spend most of your time hanging around at that shed, the hangar area?
Depends. For large groups, we would have people over there more often. If it was just me and Paul and the family, we just hang out at the house.
You mentioned kennels. Were there a number of dogs on the property?
There were, yes.
Okay. Do you remember them?
Yeah. Yes.
Okay. Tell us about the dogs you remembered. And what first of all, were there kind of two different kinds of dogs? Between family dogs or working dogs?
Yes.
Okay. Did you get to know any of the family dogs?
Yes.
Who were they? Tell us about those dogs.
Bubba is a yellow lab, and then Bourbon, brown lab, and Grady is a black lab. And they were all pretty relaxed, would hang out around the house mostly, but I don't know, they were just good dogs.
Did they? And when you slept over there, did the dogs sleep at the house location, the main house?
Yes, they did. The family dogs did.
The family dogs.
Yes.
And then there were some working dogs where would they stay? The working dogs.
They would stay in the kennels by the shed.
Yes, the location. So the Moselle location, when you started going there, did it have one or two entrances and exits?
2 entrances
Okay.
and exits.
And describe the two entrances.
So one was the main entrance that was had like brick pillar outside, and that would just kind of go to the house and not really pass anything, go through some trees. The other entrance would be next to the cabin, right behind the shed, and that entrance you can kind of go multiple ways when you go in there, but that passes by the cabin and the sheds and then goes to the house as well.
And with that entrance, is that where the mailbox was located?
I can't remember the mailbox is. I believe it was at the pillars at the main entrance, maybe.
Is that the location near the dog kennels? That second exit? you're
Yes,
talking about?
yes.
Was there one exit that was used more often than the other?
We probably more often use the one by the sheds.
If there was ever a time where someone was leaving the house and you all were down at the kennels, what was the normal course of action for that person, whether it was Mr. or Mrs. Murdaugh?
Say that again?
If anyone was leaving the house or coming back and you all were down at the shed area, the kennel area, what was the normal course of action for Mr. and Mrs. Murdaugh if they were leaving the house and exiting and you were down there?
Typically, they would come check on us and drive by and just say hey. But
That was normal?
I would say it's normal, yes.
Did you, with Paul, were you guys close enough where you shared your location with each other?
We did find my...
Tell us what that means. Is this an iPhone?
Yeah, it's the app on Find My Friends on iPhone.
And what does it mean to actually share your location with someone?
Just means any point in time you can open your phone and see where all your friends are and pinpoint their exact location.
Did you do that with many people?
Probably 5 or 10.
Do you know if Paul did that with many people?
Don't think Paul did it with many people, no.
When you spent time down at the hangar and the kennels, was it common for firearms to be stored down there or left down there?
Not common, no.
In those times, you said you've been about there about 30 to 40 times. How would you explain common? Was it something that you frequently see or not frequently?
I can't remember a time I've seen firearms left at the sheds.
When's the last time you saw Paul Murdaugh?
June 5th, I think, 2 days before.
That weekend before
Yes.
Monday of June
Yes.
7th? Tell us about that weekend.
I can't remember much. We were hanging out with my friends' houses. I think we went to a bar called the Windjammer in Charleston. But I don't remember much from the weekend.
Did you see him on Sunday?
Do not think I saw him on Sunday, no.
Did he stay at your house that weekend?
I don't think so. My friends and I were talking about that. We can't remember if it was my house or one of my other friends' houses.
Would Paul commonly stay at, when he was visiting Charleston, would he crash at people's houses?
Yes, he normally stayed at our house.
But you don't remember if that particular time he did or not?
Don't remember.
How were you kind of told about the murders? How'd you find out?
So I had missed a few calls in the middle of the night that I didn't wake up to. The next morning, my roommate came in my room and told me.
And your roommate is who?
Frank Chapman.
And he told you what happened?
Yes.
Did you make it out to the property at all?
Yes, the next day I went out to the property.
So the 8th of June?
Yes.
And walk us through what happened out there when you made it to the property. Where did you go?
We just went to the main house and just went to see the family and just be with everybody.
A lot of friends and family were there?
Good bit of friends and family, yes.
Did you attend the funeral as well?
I did, yes.
By court's indulgence? Further questions?
That's,
Good afternoon.
Afternoon.
Mr. McElveen, where are you from?
From Columbia, South Carolina.
And are you friends with Will Chapman and Frank Chapman and Will Loving and
I am, yes.
that crowd? Okay. And And so you met with Paul, I take it, down at Edisto with the Columbia group?
Yep,
And you became really good friends with Paul's, correct?
correct,
And I think you described him as a loyal friend, did you not?
correct,
And you became close not only to Paul, but to the entire Murdaugh family, right?
correct.
You know, there are houses that kids, teenagers, young adults congregate at their parents' house. Was the Murdaugh house at Edisto one of those houses where people would congregate?
It was, yes.
And you spent a lot of time at Edisto there in the
did.
summers?
I did, yes.
And you spent time around Alec and Paul and Buster and Maggie, is that correct?
That's correct.
And how would you describe Alec's relationship with Paul?
They had a very good relationship. They were kind of best friends in a way,
They were close.
very close.
And how, from your observation, how would you describe Alec's relationship with Maggie?
From everything I've seen, it was great too. I mean, nothing, I've never seen anything negative.
Right. And they liked for Paul to hang around with you, and right?
That's correct.
I mean, I think you were asked about that. You strike me as someone who's very responsible. Did they like that about you, you think?
They did, I think so.
And you strike me as someone who if you're down at Moselle, would not leave guns laying around. You wouldn't do that, would you?
Probably not, no, sir.
Okay, so when you were with Paul, hunting, you were responsible enough to be sure that guns got put away properly, correct?
Correct.
You were asked about some of their dogs. Actually, Paul had a puppy, did he know?
He did.
You have that puppy now?
I do.
What's his name?
His name's Goose.
How's he doing?
He's doing great.
Glad to hear that. And you describe 3 labs, Bubba, the yellow lab, Verdon, the brown lab, and Grady, the black lab?
That's correct.
And when you were at Moselle, I mean, these were family dogs, and they stayed up at the residence?
That's right.
Now, up at the residence, they had an invisible electric fence around the house, correct?
I didn't know about it, but possibly so.
Okay. Well, was Bubba a handful that just take off sometimes?
Sometimes.
Right. And you don't know, when was the last time you were at Moselle?
I can't remember.
Was it in 2021?
Most likely.
Okay. Were the dogs there?
I can't remember.
When you heard that Paul had been murdered, did Will Loving come down to your house in Charleston, or was it another friend's house?
Will went to another friend's, but I think he came to our house later in the day. But we had a group at our house as well.
And then you went to Moselle?
The next day we went to Moselle.
Would that have been on that Wednesday? Murders were Monday night, late.
So yes, I guess that Wednesday we went to Moselle.
So not the Tuesday, but the Wednesday.
I believe that's correct.
And who all went with you?
I think Frank Chapman went with me. And that might be it.
Okay. And who was there when you got there? Were any other any other friends of Paul there when you got there?
Rogan was there, and Nolan was there.
And what was?
There might have been a couple more, but I'm not sure.
Okay. What was Alex Murdaugh's demeanor when you saw him?
Just sad, crying.
Did y'all hug?
We did hug, yeah.
I mean, did he when he was crying?
Yes.
And did you go back over to Moselle after the funeral?
Yes, I did.
And were there a bunch of Paul's friends there?
There were, yes.
And can you tell me, was Alec, is he still crying, hugging all the Paul's friends?
He was still crying. I mean, there were so many people there that it was kind of a line to see him, but from the little bit I saw him, yes.
One second, Your Honor. Do I have anything further?
Anything further? Thank you. You may step down. Break. Addressing the jury, 15 minutes break.
Please be seated.
Is there anything before the jury comes?
Shouldn't be a complicated issue, but Mr. Waters and I are complicated people.
Yes, sir.
To this charge. And of course, obviously, Your Honor, it's a suggestion to you.
Yes, sir.
We're just suggesting that you obviously have the authority.
All right, Mr. Waters.
Your Honor, I don't know if Your Honor has another instruction that you prefer. I probably would do the language just a little different in that particular one, but I think fundamentally the principles are accurate. I do think that the next to last sentence is superfluous because that's already said, but I think that's fine. And in the end, I don't think that there's too much that we have an issue with that particular charge.
And Your Honor, other matter before we bring the jury in, would you want to hear from me now? The state intends on introducing through, not this witness, if this witness is another witness, the GSR person, specific GSR person.
That's correct. It'll be the witness after this.
Okay. Evidence of GSR gunshot residue on that blue jacket. We would object to any such testimony under a 403 analysis. Prejudice outweighs the probative, and I'm struggling to figure out what the probative is. So I'm in this. I think it's factually driven. I think the state needs to give you some sense of what it proves. A jacket, I might point out, no one has put in the hands of the defendant. And the tarp that they found, they never tested for GSR, blood, DNA, and everyone says tarp. That's a jacket. I don't know how you connect it to the defendant. If the prejudice far outweighs any probative value in that it's not been connected to him, even circumstantially not connected to him. The only witness to it, Shelley, who I've talked to a couple times, indicated that was not what he had in his hands. She'd never seen it before, never seen it with him. So, Your Honor, we'd oppose it under a 403 analysis.
Yes, Your Honor. I think if you listen to the testimony of Ms. Smith in totality, first of all, she identified a picture where she said, yeah, that looks like what it was. It was balled up, and that picture, of course, was then identified by Ms. Moore as where they recovered the actual raincoat, which of course is a very, very large raincoat and very easily could be identified as a tarp. I think any issues that Mr. Harpootlian wants to make, he can certainly argue those to the jury, but the connection has been established between Ms. Smith and that particular raincoat, and looking at the picture and saying, that looks like what I saw. Additionally, with that other tarp, she also testified that there was no silver on that tarp, and if you look at the picture of that other tarp, it is half blue and half silver, so it's a very...
Which other tarp?
There was, I think, Miss, and I'll have to find the exhibits for me real quick, Your Honor. Today, yes, please. So, Your Honor, and I can put them up with the elbow or hand them up, whichever you prefer, but we have State's Exhibit 224, and this was a tarp you can see with a lot of silver on it, but State's Exhibit 411, Ms. Smith identified as that's what it looked like. You can see that balled up thing right there, and that is ultimately the rain jacket, which, as you saw, particularly on redirect with Ms. Gowd, this is extremely large, very easily could look like a tarp, and when she balled it up, Ms. Smith said, yeah, that's what it looked like. So I think there's been enough of a nexus established as to the probative value, and what you'll of course hear is that from the GSR experts is that very high levels of GSR were found within the inside of that blue rain jacket, which again is this big and very, very long. Again, Mr. Harpootlian can argue to the jury whatever inferences he wants to, but I think the state has established enough of a nexus to not only make it relevant, but to make its probative value not substantially outweighed by the danger of unfair prejudice.
Yes, sir.
I think he either misunderstood or is misquoting what Ms. Smith said. She said, when she was shown that photo, she said, it's the same color or like the same color. She never, ever, ever said, that's what I saw him with as he came through the door. And by the way, she found the tarp. That couldn't be the tarp because the tarp was found downstairs across a chair, which is what she said he walked in with. So the tarp in the box obviously isn't it. And I mean, she said the tarp that he came in with was the one that was on the chair when he came down, not the coat. All she ever said was that blue coat, balled up, appears to be the same color. No one has ever said that she saw him or anybody saw him with that jacket. And I would also point out that I hate to say this, but I would suspect there are a number of rain jackets in this area of the state that have GSR on them, in them, around them. So there's no one that says he had possession. All she ever said was, and by the way, it was all balled up. All she said was, it looks like the same color. She saw a picture of the rain jacket and said, that is not what he was carrying when he came in.
All right. The item is in evidence. The witness testified as to the location of the item of evidence and where she believed that it was placed by the defendant. It's in evidence. Obviously, the state contends that it has some inculpatory evidence on it. This is a circumstantial case, and circumstantially, proof may be offered on the issue of whether or not this gunshot residue or whatever it might be can be traced to the defendant. And I overrule the objection, and I find the evidence offered is more probative than prejudicial, though I do not believe a probative versus prejudicial analysis is required on this issue. But to the extent that it is, I find that it's more probative than prejudicial, and I deny the motion to prevent the state from offering testimony.
Accept your ruling.
Yes, sir. If you bring the jury.
The jury is present, sir.
Thank you. Your next witness. State's next witness.
Johnny James for the state calls Natasha Moody.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
My name is Natasha Moody, last name Moodie.
I spelled it with a Y on my paper, I'm sorry.
It's okay.
Miss Moody, where are you from?
Jacksonville, Florida.
And for whom do you work?
Bank of America, NA.
What do you do for Bank of America, NA?
I am a consumer resolution associate.
Consumer Resolution Associate. What does a Consumer Resolution Associate do?
I manage a portfolio of litigated matters. I appear on behalf of the bank for trials, depositions, mediations, and I also review our business records on a daily basis.
Your business records, were you asked to review business records for Bank of America, NA in relation to this case?
I did.
I am showing you 3 items labeled for identification as State's Exhibit 415, 416, and 417. Do you recognize these items?
I do.
And how do you recognize them?
I reviewed them and I also initialed them.
And generally speaking, what are these items?
These are documents for this case, opening account documents, monthly statements for various accounts, and copies of checks for this account, for various accounts.
So are they bank records?
Yes.
Your Honor, State moves to introduce Exhibits 415, 416, and 417 into evidence at this time, my understanding, with subject to any objections from Your Honor's previous ruling off today.
Yes, sir. Ms. Harput.
Your Honor, may I confer with Mr. Murdaugh?
Yes.
Prior to the admission of these records, I would ask you to give whatever cautionary charge you're going to do.
All right. Be happy to. Ladies and gentlemen, evidence or testimony is about to be offered that the defendant may have been involved in other criminal activity. And that evidence is not evidence or proof that he committed the offenses charged in the indictments. This testimony has been allowed and is being allowed for the limited purpose of assisting the state in proving motive. You may not consider this evidence for purposes of character of Mr. Murdaugh, nor may you consider this evidence as evidence of his propensity to commit other crimes, or that it is more likely that he committed the crimes with which he is currently on trial. It is being allowed based on the state's representation that it helps explain the defendant's motive to commit the crimes for which he is accused. And you may proceed.
Very briefly, Ms. Moody, we had 3 discs that are now in evidence. What information is on that first disc? You indicated that it was bank records. Do you have any additional information to describe those bank records?
I do, but I don't have the disc in front of me.
Oh. Showing you State's Exhibit labeled 415. What records are on that disc?
There are checking account ending, it involves checking accounts, and I can give you the last 4 digits of those.
If you would, please.
Checking account ending in the last 4 digits is 6779. It has account opening documents for that one. The next one is account ending in 7991, and those are account opening documents for that account. And then checking account ending in 7625, and that's account opening documents for that account, and then also monthly statements and supporting documents for all 3 accounts.
Thank you. Now showing you State's Exhibit 416. What's on this disc?
These are credit card ending in 9559. And those are monthly statements in that, and account opening application documents.
State's Exhibit 417. What's on that disc?
Also another credit card ending in 8591, and these are application accompanying documents and monthly statements for this account.
Are in evidence, but we would not have any objection to them except as to our previously made objections.
Yes, sir.
State moves to admit these 3 exhibits. No further questions for this witness, Your Honor.
No questions.
Thank you, Ms. Moody.
Moody.
You may step down and you're excused. Let me call the next witness.
statement now called Jamie Hall.
Right hand on your, raise your right hand, left hand on your Bible. Yes. Do you affirm the testimony about to give the court shall be the truth, so help you God?
I do.
State your name again for the record. Spell your last name, please.
My name is Jamie Hall, Hall.
Good afternoon.
Good afternoon.
Where do you work?
I'm currently employed at the West Columbia Police Department as an evidence custodian
How long have you been there?
since April of 2022.
Will you please tell the ladies and gentlemen of this jury about Jamie Hall, as much of your background, as personal background as you want to? I'll leave that to you, but specifically your education and background that led you to law enforcement, please.
Yes, sir. I grew up in the Midlands area of South Carolina. Upon graduating high school, I attended Clemson University and attained my Bachelor's of Science degree in Wildlife and Fisheries Biology. After that, I spent a couple years traveling and working some various jobs. I moved back to the area in 2013 and began looking to start a career, and ended up at SLED in 2015 as an administrative assistant in the Trace Evidence Department in the Forensic Services Laboratory. I was an administrative assistant until 2017 when I became an evidence technician, a forensic technician too, in the Trace Evidence Lab.
When did you graduate Clemson?
In 2010.
Okay. So after you traveled some, you started working in SLED in what year?
In 2015.
Okay. What was your job then?
I was an administrative assistant.
And what does that mean?
For the Trace Evidence Department, that involved answering phone calls, filing documents, pretty much normal administrative duties.
Did you further your education or your experiences while you were at SLED in that field?
No, sir. When I became the technician in 2017, that's when I began the in-house training for that career.
Okay. Tell us about the in-house training when you became the forensic technician.
Yeah, so that training involved oral and practical examinations in-house under the supervision of an analyst, in which I learned how to properly handle the evidence and process the evidence for potential GSR. I also oversaw some testimonies of some analysts to be familiar with courtroom policies as well. And I took some outside training from Hook College in Chicago as well.
Hook College in Chicago?
Hook, yes, sir.
And what was that training?
It was training regarding the scanning electron microscope, which is used for GSR analysis.
That's the acronym is SEM for that?
The SEM, yes, sir.
And when did you leave SLED?
In March of 2022.
Okay. And do you mind, you're working where now?
At the West Columbia Police Department.
West Columbia Police Department, and you are there what?
Evidence custodian.
Now, back in June of 2021, you were a forensic technician for SLED.
Yes, sir.
Special agent, forensic technician?
No, sir, I was not considered an agent or considered law enforcement. I was just the forensic technician too.
Okay. So then, in June of 2021, what was your job on a day-to-day basis?
My primary role in the Trace Evidence Department as a forensic technician was to prepare evidence for GSR analysis. That include GSR kits as well as inanimate objects that came in for potential GSR testing.
And we're going to have Ms. Fletcher testify right after you, but what is a GSR kit?
A GSR kit is an envelope that goes out to officers or investigators so that they can collect on scene from a potential suspect's hands. And it involves, it has all the items they need: gloves so that they can make sure they're not contaminating the subject's hand. And then the little vials that contain the GSR particle lifts with a double-sided adhesive that's used to dab across their hands to pick up any potential GSR.
So those are kind of done in the field, if you will?
Yes, sir.
After a local law enforcement agency uses one of these kits, what happens to it?
When they decide that they need it analyzed, they submit it to the laboratory, and then when it comes into the laboratory, I prepare it for analysis. So that involves me making sure it's been properly sealed and initialed, handled properly, the correct kit. There are a variety of kits out there. Our lab has particular kits that we accept, so I confirm that it is an acceptable kit. And I also confirm that it was collected within the allowed time frame. On a living person, we're touching things all the time and possibly contaminating or removing the GSR. So we do have a 6-hour time limit on kits collected from individuals.
So if a kit comes into SLED or your possession, do you check to see if it was collected during that 6-hour time period?
Yes, sir, I do.
And how do you do that?
We have what we call an information worksheet included in each GSR kit that the officer fills out that includes the time or the estimated time that the shooting occurred, as well as the time that the kit was collected.
I'm going to show you what is marked States 13. Can you tell if you were involved with States 13? And if you can, how can you tell?
Yes, sir. This has a unique SLED lab number and item number, and it also has my initials on the day that I processed it.
6821 JEH.
Yes, sir.
What's the E stand for?
Elizabeth.
Now, Court, would you open this, please?
Thank you.
Did you examine States 13?
Yes, sir. Again, it also has my date and initials from the day that I processed it.
Your initials again, JEH?
Yes, sir.
6821?
Yes, sir.
And when you're processing this, tell us again, what are you looking to see, whether it's what's done or not, or just tell us what you
Okay. So for a GSR kit, I start by using what we call an inventory worksheet. And on that worksheet, what I'm doing is confirming the manufacturer of the kit as well as the lot number for the kit. They have lot numbers for quality control purposes to make sure they're not contaminated before they're used for collection. I'm confirming who the kit was collected from, that 6-hour time frame. And during that time, I also label the individual particle lifts inside with the unique lab number, item number, date and initials for control purposes.
And I believe a sheet has been entered where Murdaugh collected this GSR kit from the defendant. Are you aware of that?
Are you referring to the gunshot residue analysis information sheet?
That's exactly what I'm referring to.
Yes, sir. That's what I would have used to confirm the 6-hour time frame.
And it's in evidence already. I'm not sure exactly what number, but do you have that copy?
Yes, sir, I do.
Okay. And this has already, if you'll trust me, this has already been entered into evidence. Did you use this in examining, determining whether this was collected properly?
Yes, sir, I did. It also has my date and initials on it.
So using the form, show these ladies and gentlemen what you did. How you came up and...
There's a section here at the bottom. So we have the subject's name from whom it was collected.
And who is that?
This one says Richard Alexander Murdaugh.
Okay.
As well as the time and date the shooting occurred, 6/7/21, 10 p.m.
And that's information that's gathered at the scene from somebody, right?
Yes, sir. This particular kit says that it was filled out by collecting officer Brian Vandor. Sorry if I messed that up.
That's good enough, okay.
And then at the bottom, the collecting officer has also signed and dated that it was collected at 6/7/21 at 11:15 p.m.
And would that 11:15 fit in the time period where you're saying, okay, well, I can pass this on to be analyzed?
Yes, sir. It's an hour and 15 minutes.
And so, not taking away from what your job at all, but one of your jobs is to make sure that's done correctly? that
Yes,
form?
sir.
And then do you inspect the vials, if you will, to make
Yes,
sure?
sir. I make sure that there's nothing out of the ordinary with them. Occasionally, you would have a little crack in the vial, but I've never had anything damaged.
So in your opinion, these were collected properly and you passed them on for analysis?
To the best of my knowledge, yes, sir.
Now, were there, let me ask you this much. Local agencies that you examine items for potential evidence, in this case gunshot residue, how did they get to the lab?
Typically, the officers from the local agency submit them through our evidence control department. And once they're submitted that way, that's when they're assigned their unique lab number and item numbers for each piece of evidence. And then based on the type of analysis that that agency requested, we would get notice that it needs to be processed. And so I would pick it up from evidence control and bring it upstairs to the trace lab to begin the processing.
And is all that documented from local agency to y'all and where it goes from there?
I can't attest to what the outside agencies do. I believe it probably varies agency to agency. But once it's been logged into our system downstairs, it is tracked throughout the laboratory for every hand that touches it.
That's kind of what we refer to as a chain, correct?
Yes, sir. It's
Chain of
referred to as the
evidence.
chain of custody.
Chain of custody. Now, did you have some other items of potential evidence in this case that you examined?
Yes, sir. I had several other items.
Okay. I'm going to show you what's marked States 418. Ask me if you can just identify this, Ms. Hall, and does it relate to your testimony?
Well, I can no longer see my initials, but I did process items that were in container D, and this is marked with container D for this case number. Yes, sir.
And would you open it up then to see if you
Yes.
can further find your mark with the court's permission? Mark 21, excuse me, it's your lab number 21 contained in States 418 at this point for identification. Do you recognize that?
Yes, I recognize it as the lab item number 20.
And what is lab item number 20?
It was a brown paper bag containing one pair of green cargo shorts.
And also contained in 418, lab number 21. Can you tell me if you recognize that?
Yes, sir. It's lab number, or item number for this case, 19, which was a brown paper bag containing one white T-shirt.
Now, okay. 418 without objection.
They're admitted.
I'm going to show you what time. Thank you, Your Honor. Sorry. I'm going to ask you, please, ma'am, this is a crazy question. Look at 423, 424, and 425. Do you recognize these, and do they relate to what you're talking about right now?
Yes, sir. These are PGSR collection worksheets from clothing that I generate during my process of collecting from inanimate objects.
Okay. Inanimate objects.
Yes, sir.
Okay. Now, let's start with the shirt, 423.
Yes,
It's
sir.
in evidence. Tell these folks what you did with the shirt.
So anytime we're processing clothing or an inanimate object in the lab, we start by making sure everything's been thoroughly cleaned, and we also place down parchment paper to just as an extra check and balance to make sure there's nothing contaminating the evidence. We also place what we call a clothing blank out onto the table where we are processing. That's just another one of those double-sided adhesive stubs, and it's left open and exposed to the environment to make sure there's no contamination in the environment. That's how I start all of my clothing. Then I confirm that everything is adequately sealed and documented, and I open my items and lay them out on the parchment paper. I photograph items, and then I do label those items for identification later if needed. And then I will sample the clothing item closest, in the areas that would be closest to the discharge of the firearm. So in this case, we're talking about a t-shirt. So I will sample the right chest and sleeve area together and the left chest and left sleeve together. So if you want to draw a line down your midline for right and left, and then we typically go down to just below the chest area.
And is that what you do with every shirt?
Yes, sir. If it's a long sleeve garment, I would typically use a separate particle lift for the chest area and the arms, just because the adhesive doesn't last quite as long.
And if you said this, I apologize, I'm tired. Why are you doing those areas?
It's closest to the discharge of a firearm.
Potential discharge, so that's where you test it.
Yes, sir.
Well, looking at the shirt, look 418, the shirt that's contained in here. Which one's the shirt?
19.
19?
Yes, sir.
Before you get to doing the particle lists, what's the first thing you do?
I confirm what the item is and that it's properly sealed and initialed.
Do you open it?
After I clean, I open it. Yes, sir.
And do you make observations of items when you first open it?
Yes, sir. Anything that seems out of the ordinary for any item is documented on the worksheet in the comments section.
And you have a comment section. That's where you put your thoughts, right?
Yes, sir. Anything that may, again, be out of the ordinary or affect the analysis later.
And just to go back, you go down a little bit. Yeah, so this is right sleeve, right chest, left sleeve, left chest. Hanes beefy shirt, right?
I don't have any objection to introducing 423 into evidence. I don't think it's in evidence yet, but no objection.
We offered it a little while ago without objection. 423, 24, 25.
I have no objection to those three exhibits going in.
I thought I'd said that. If I didn't, I apologize. Is this a Hanes beefy t-shirt?
Yes, sir, it was.
And item 19.1, what are your comments underneath there?
Small reddish brown stains observed. Shirt had an odor of laundry detergent.
What do you mean by that, an odor of laundry detergent?
It just smelled freshly laundered, which is not typical of the lab. Typically, clothing smells slightly musky when we get it.
And you examined this shirt when?
On June 8th of 2021.
Now, you didn't know, did you have any knowledge about this case whatsoever?
I just knew that we had asked to make it a priority in the lab.
And you attempted to collect particle lists from that shirt?
I did collect particle lists from the shirt, yes, sir.
Next, states 425, sorry, we're out of order here. This is also your clothing worksheet?
Can I see the top of that sheet? I'm sorry.
I'm sorry.
Oh, yes, sir.
And what was this that you examined?
This was the worksheet we generated when we collected from a seat belt that was collected from a 2021 Chevy Suburban, South Carolina tag CZL420.
And I think we have it marked for ID only. Do you recognize this? Right there, I'm sorry. The seatbelt states 100. Thank you to everybody. States 100. Can you look at this and see if you haven't examined that before? Does it relate to your testimony?
Yes, sir. This was sled item number 142, and it also has my date and initials on it as well.
All right, what did you do with states 100?
At the direction of the analyst, Megan Fletcher, I collected samples from various areas on the seatbelt.
Can you tell the ladies and gentlemen of the jury, how did you determine where you were going to collect samples?
Since this was not our typical item, I collected from areas in which Megan instructed me to collect.
Which was where?
We collected from the buckle, 3 different areas of the belt, and the latch plate.
Can you show the jury where you collected?
Yeah. So this, I believe, was what we call the latch plate.
Okay.
Sorry if I'm misspeaking on that, but, and then the buckle was, oh gosh, this area here, and we did the top and bottom of it. And the 3 sections were just, we measured the length for each section, did a section, rolled more out, and did the next section.
And how are you actually doing it with the particle lifts? How are you collecting them?
So, as stated before, the particle lifts have a double-sided adhesive on it, and you just repeatedly dab that across the garment or the item that you're collecting until it loses its adhesive abilities.
100, we'd offer, Your Honor.
No objection, Your Honor.
Thank you. And looking back on the sheet, this noted here, that's where you went through and did your inventory sheet, correct?
Yes, sir.
And this is to document you did what you did, right?
Yes, sir.
Now, did you also have an occasion to examine the pants in this case? It's already, I believe, in evidence.
I did collect from some cargo shorts.
And those were also included on what I just took down off the OMO, but can you tell the folks where you collected or tried to collect lifts off the cargo shorts and why you collected in those areas?
Yes, sir. For any type of pants or shorts, we always collect from the right groin and the left groin area. Again, that's the area that's closest to the discharge of a firearm.
And that's standard, that's what you do?
That is standard practice.
Now, did you,
Is that correct, Mr. Griffin?
Yes, Your Honor.
It's admitted.
Would you mind opening up for, first of all, do you know whether or not you examined a pair of shoes in this case?
I did, and these are the shoes, sled item number 21.
Okay. Would you please open that for the ladies and gentlemen?
Yeah, it's gonna be a lot of stuff on it. I use gloves.
Sure. Yes, ma'am. Before you're cutting that, do you see JEH on here?
Yes, sir, I do. On 6/8/21, I signed my initials.
What is all that right there?
I believe it's yard debris.
Court permissions to dump this right here, or can I get a trash can? These are states 419 in without objection. Can you show these to the jury?
Sir.
Show the jury what you, I'll hold them. Show the jury what you,
So with shoes, when we collect from them, we're gonna collect again to the area that would be closest to the discharge of the firearm, so the front of the shoe. So in this case, I would do the area where the laces would typically be and the front toe. Depending on how well the adhesive continues, it will depend on how far back I go, but I start with the toe and then work my area down the sides.
is this the condition they were when you saw them on June 8th, 2021?
There was more grassy type material on them when I had them.
Okay. And what I just dumped in the trash can with the court's permission and in here, did you indicate on your comment section
Yes.
whether or not yard debris was present?
Yes, sir. I commented that shoes were wet with yard debris present.
Wet with yard debris.
Yes, sir.
Did you, on June 8th now, go back in your mind, when you saw these, in addition to wet and yard debris, did you make any other notes in the comment section about those shoes?
I did not.
Do you remember, did you see anything that looked like blood?
I did not make any note of that. No, sir.
With your naked eye?
No, sir.
Top or bottom?
No, sir.
Okay. Did you have any other items that you examined that were presented to you for examination either by yourself or with Megan Fletcher?
Yes, sir.
What was that?
It was sled item number 173. And it was, we described it as one blue rain jacket / poncho.
Okay. And was this the same, no. When did you examine the poncho?
I believe we began on October 5th, 2021.
Okay. So is it fair to say that the clothes, the shirt, the pants, and the shoes were on June 8th of 2021?
Let me check my notes. Yes, sir, that's correct, June 8th of 2021.
And I didn't ask you this, and I apologize. When did you examine the belt, the seat belt?
The seatbelt was examined on September 1st, 2021.
And again, the specific date for the raincoat was what?
October 5th, 2021.
And tell the ladies and gentlemen, take us to the lab now. How did you examine that garment, the rain jacket?
This was also not our typical garment, and I believe there was some information provided from investigations. So everything I did in this case was at the direct, or in this, for this particular item, was at the direct supervision of Megan Fletcher. She essentially told me where she would like me to collect, and she documented everything on the note sheet while I physically collected the particle lifts.
Is that correct?
That's correct, Your Honor.
They're admitted.
And Your Honor, 421 are the particle list from the rain jacket, and I believe there's no objection except the further the objection they made previously. No additional objection, 421.
They're admitted.
So let me go back in time real quick. Are these the particle lifts you took from the seatbelt? 427?
Yes, sir, my initials are also on each individual stub.
And that's sort of like the officer has in the scene. You're now doing it in the lab, taking particle lifts, correct?
Correct.
And particle lists from 420 lists from 1920 and 21, which I think are the pants, the shirt, and the shoes. Were these the particle lists from 420 that you actually took?
Yes, sir.
Again in the twos.
Yes, sir.
And your initials is on.
Yes, sir.
Now, 421, you said it was a little different, unusual. How did you take the particle lifts on this rain jacket?
I believe everything was considered in Megan's custody while I was doing the collection, and then it was transferred directly to my custody when I carbon coated the particle lifts. That's just a process where a thin layer of carbon is added. It allows the analyst to get better images on the instrument. It doesn't do anything to add or remove GSR. It just simply adds a very thin layer of carbon. So it was in my custody at that time, but prior to that, it was in Megan's custody.
Okay. Show you what's marked as 226. Is this the rain jacket that you were describing?
If I can check the bottom cuff. Yes, sir. The date and my initials are here in the bottom cuff.
So you looked at this rain jacket,
Yes, sir, I did.
and Megan Fletcher was with you.
Yes, sir.
And tell the ladies and gentlemen, how did you process? Where did you attempt to get particle lifts?
Basically, the entire garment. We marked it off in different sections, again, where Megan advised me to collect from, and I repeatedly dabbed the particle lift across each section. until it lost adhesive.
These particle lifts?
Yes, sir.
You dabbed each one of these?
Yes, sir.
Okay. And what are these little things on here? These tape or the?
I'm not sure what those are.
Now, you did the outside of this garment.
Correct.
Did you do anything else to it?
We also sampled the inside of this garment as well.
So you actually turned it inside out and took samples from the inside.
That's correct.
Megan Fletcher was with you.
Yes, sir.
What about the hood? Did you test it or take samples from the outside of the hood?
Yes, sir, we did.
Did you take samples from the inside of the hood?
Yes, sir, we did.
Pay the court's indulgence. I'm not wearing gloves here now, but when you're examining all of these items, do you wear gloves?
Yes, sir.
Does Megan Fletcher, did she wear gloves?
Yes, sir.
Why?
To make sure we're not contaminating it, as well as to protect ourselves from anything that may be on the garment.
And as far as the, to not contaminate it, you don't want to put anything of you on that garment.
Correct. It's standard practice for us to wear a lab coat, gloves, and if it's going to be processed for DNA later, we also wear a mask.
And is that in a controlled environment when you attempt to get these particles?
Yes, sir.
Thank you, Judge, that's all.
By the defense.
Yes, Your Honor, thank you. Exhibits 423.
Oh, you do, I'm sorry, yeah.
Good afternoon, Ms. Hall.
Good afternoon.
You said if you're going to do DNA testing, you wear a mask.
Yes, sir.
Did you wear a mask?
Yes, sir, I did.
So, to your knowledge, were some of these items processed for DNA after the GSR processing?
It was my understanding that they had the potential for DNA analysis. Yes, sir.
Okay. Now, let's just talk about how you go about sampling for GSR. And you talked about the shirt, and you said you would do the chest and sleeve on either side. How does that work? Do you lay the shirt out on a table?
Yes, sir. So as I stated, the table is thoroughly cleaned, and then we place down parchment paper as well, sterile parchment paper, and lay the garment out on that so that we can access all the areas.
And for the shirt here, I think it's item 19, did you just check on the two areas at the top on the chest side?
Yes, sir. Unless we're given information from the investigative team or from an officer who submitted it that there's potentially a reason to test somewhere else, we only test the chest and sleeve area because that's the area that would be closest to the discharge of a firearm.
And that's what you're looking for is, do you call it gunshot residue, is that right?
Yes, sir. It's microscopic, so you cannot see it. Therefore, we're testing the areas where we would expect to find it.
And you would expect to find gunshot residue on the shoulders of a person who had recently shot a gun, I would take it.
Yes, sir.
That's what you're looking for.
That's what we're trying to find out, yes.
Right. And then you did some GSR testing of a seatbelt assembly and buckle and whatnot, correct?
Correct.
Okay. And you did GSR testing of this rain jacket here, right?
Correct.
And shirt, shorts, shoes, and Officer Varnado, I think's his name, you received a sample from him, and you just checked to be sure it was off.
I didn't
Murdoch's
physically
hand?
receive it from him, but he was the collecting officer listed on the sheet, yes, sir.
Okay. And so he would have taken the sample, or whoever did it would have taken it from Mr. Murdaugh, and that would be item number 18, I believe?
Sled item 18, yes, sir.
And those are the samples taken from Mr. Murdaugh's hands, I take it?
Yes, sir.
Okay. Now, you can get gunshot residue on you by just simply picking up a firearm, can you not?
Those questions would be better asked of the analyst. I can only testify to factually what I did.
Okay. And the analyst here is Ms. Fletcher?
Yes, sir.
Okay. Let me ask you to take a look at your worksheet, which is in evidence 423. And do you have that up there?
Yes, sir.
You know, I think I'd rather put it on the Elmo so we can. Do you have it in?
I have my copy, yes, sir.
Okay, great. So, all right. Yeah, go to the top. Okay, let's stop right there. Agent Hall, it says that this was a brand Hanes beefy T-shirt,
Yes, sir.
and then particle lifts, right sleeve, right chest, left sleeve, left chest, correct?
Correct.
And it says description, paper bag containing one white T-shirt. Is that right?
That's correct.
And then and Doug, if you'll go up, down a little bit more, okay. And then there it says, comment, small reddish brown stains observed. Shirt had odor of laundry detergent. That's what it says, correct?
Correct.
Do you know what those small reddish brown stains looked like?
They looked like small reddish brown stains on the shirt.
Were they tested?
I have no knowledge of what was done after I handled the object.
Okay. Now below here it says sealed brown paper bag containing one pair of green shorts. Is that just an entry for another item?
Yes, sir, that's item number 20. The sheet is designed where we can put two items on one sheet.
Okay. So when you received the shirt, item 19, was it in its own separate bag?
In this case, it was, yes, sir. That's why I made the note that that individual item contained its own brown paper bag, why the description says brown paper bag containing.
Okay. And the shorts, those are green cargo shorts, and again, you lifted, it says right groin, left groin.
Correct.
And it's just on the, is it on the inside of the pants leg, or?
Well, it's on the outside of the garment, down to, a reasonable distance, depending on the type of fabric, could depend on how much adhesive it has, depending on how large the garment is from the person. A small garment versus a 3XL is completely different. It depends on how far I can go down on the garment.
And to do this, you take a sticky something or another? And
It's a
just-
double-sided adhesive on an aluminum stub within those little vials. The bottom has a holder for that, and then we grip it by the bottom and repeatedly dab it across the garment.
Until it loses its stickiness.
Correct.
And then, do you do one vial per area or multiple vials?
It's one vial per area listed. If for some reason I needed to use an extra vial or an additional vial, that would have had its own listing on the worksheet.
Okay. Now, I tell you, you don't know what the results of your lifting were, do you?
No, sir, I do not.
That, you would then finish your work and send it up the chain?
Yes, sir. All the items are either given directly to the analyst or they're securely stored in the trace evidence lab until the analyst takes possession of them.
And this blue rain jacket, you said you put carbon on it or something?
Yes, sir. It's a standard practice for anything collected from an inanimate object. We typically get a lot of debris, sand, dirt, or fibers, typically from clothing, and that can cause it to be a little bit more difficult on the instrument for them to get pictures of the particles. So the carbon just allows them to get a better picture of the a better picture of the particles when they do their analysis, but it does not do anything to add or remove GSR.
So you put the carbon down before you use your sticky thing?
No, sir, that process happens after the collection.
Okay.
So it goes into a small device, and there's little rods of carbon that are rubbed against each other inside of the instrument to put the layer of carbon onto it.
I see. But you're not putting carbon on the garment?
No, sir.
Got it. Okay. One second, Your Honor. Ms. Hall, are you involved in any way with DNA processing?
No, sir, I'm not.
Okay. And so you don't know whether any of the items were processed for DNA?
I have no knowledge of where the items went after they left my department.
Okay, thank you so much.
You're welcome.
No, sir. Thank you.
Thank you. You may step down. Unless you have a 2-minute witness, this will be it for today.
We don't, Your Honor, unfortunately.
Ladies and gentlemen, that'll do it for this day. We'll resume at 9:30 tomorrow morning. Please do not discuss the case.